They. Okay.
I'm also praying for the same relief. I'm also praying for moving an unlisted motion, my lord.
Huh?
I'm also praying for listing an unlisted motion today, my lord.
But prayer for listing a matter for motion on 19 not completely.
May it please, your lordship, my lord, with regard to item number 46, I would like to indicate something to your lordship. Lordship permits, my lord. What had happened, my lord, in this case on Tuesday, my lord,
Number?
46, my lord.
Hmm.
Last Tuesday, my lord, the matter was finally heard and judgment was also dictated in the open court, my lord. But due to some query, it has been fixed today for passing of final orders. So the matter has come before your lordships, my lord. I am ready to do it in this court also, my lord, but I thought it would be proper for me if I indicate it to your lordships, my lord. It's recorded in the order also, my lord, in the file.
Before court number?
Court 18, my lord, Honorable Mr. Justice A. Kalita. It's indicated in the order sheet also.
We'll see.
Lordship, I beg to mention listing of the withdrawal, Lordship, as per what is Lordship convenient date.
When?
Withdrawal, Lordship.
When?
As per Lordship convenient date, Lordship. Tomorrow maybe,
19th?
19th, Lordship.
May it please, your lordship.
Has been submitted by Mr. B. Sharma, the learned counsel appearing on behalf of the petitioner, drawing the attention to the order dated 6/1/2026, passed by a learned coordinate bench of this court, that a matter is part heard before the said bench. Taking into account the above, the registry shall do the needful.
The interim order, my, there's an interim order.
Shall do the needful. The interim order passed shall continue till the next date of listing.
Much.
Praying for listing of a matter for tomorrow. Listing of a matter.
Or
For tomorrow.
why? Motion?
Motion.
May it please your lordship, in item number 45, we have filed our affidavit yesterday that may be called for. Much obliged.
Lordship, I'm seeking your lordship's permission to move and matter tomorrow for motion, your lordships. Deeply obliged.
May it please your lordship, item 13 and 14 lordship, yesterday we have filed one affidavit lordship. Add to fix matter, my lord, that may be called.
39 and 40.
13 and 14.
Okay.
13, 14, that add to fix matter. Green Road bus matter, my lord.
You filed an affidavit?
Yesterday, lord. Obliged.
Lordship, I'm back to mention item number 43, Lordship. The matter was taken up at 2 o'clock, Lordship.
Item number?
43 supplementary.
Why?
The Lordship, Learned Council is to enroll in medical agency, Lordship, this part of what my story, Lordship. Within hospital, Lordship.
Chalo, we'll see.
Much obliged.
May it please your lordship, with the consent of other side, I beg to mention item number 6. The conducting counsel, Mr. B. Pathak, is in bereavement.
It has been submitted that Mr. B. Pathak, the learned counsel who representing the petitioner, is in bereavement. So consequently, matter stands adjourned to be listed again on 10th of March 2026.
May I please, on motion matter, may I pray for listing tomorrow, my lord? Bless you.
May please, your Lordship. I wish to mention item 17, my lord, 17, my lord. Matter is in fact infectious, my lord. The petitioner is not interested to continue the case, my lord. Matter may be withdrawn.
Your name?
Matter may be withdrawn, my lord.
Your name?
A.N. Ahmed.
Mr. A. N. Ahmed, the learned counsel appearing on behalf of the petitioner, submits that the writ petition has become infructuous. The taking into account the above, the writ petition stands closed. Interim order passed any stands vacated. Mr. A.M. Khan appears for response number 7.
First item.
May I please, Your Lordship, on yesterday, my lord, they have filed their affidavit, my lord. I've,
That affidavit would be necessary, Lordship, in record,
my
Lordship.
lord, gone through the affidavit, my lord, and my lord, I have seen the rules also, my lord, rule 68A specifically. And my lord, looking at the affidavit, my lord, there is a direct violation, my lord, to rule 68A. I will showcase that, my lord, because of the fact that, my lord, as per rule 68A, the petitioner, the marks which they have given, if your lordship gets, if your lordship has the.
I have.
I don't have a copy.
The copy will be necessary, my lord. Lord can have, accept this. Lordship, I can showcase. No copy, no copy. Listen to the.
Yes.
Lordship will come to page number 130 of their affidavit. 130. This is, they have given the breakup of the marks of the petitioner. There, my lord, with Lordship will see name of the paper and marks obtained. My lord will see education 1, education 2, sociology 1, sociology 2. My lord. And then your Lordship will come and see, my lord, below that, general studies and general English. My lord. General English has scored 149 and 196, my lord. Whereas, my lord, if your Lordship comes to the second, response number 8, political science, veterinary science, these are all optional subjects, my lord. Then, my lord, the compulsory subjects, my lord, are general studies and general English, my lord. Same. Now, Lordship will come to the rules once, my lord. The rules which I had given that day, my lord. Rule 68A, my lord. 68A. Your Lordship takes up the rule 68A of the APSC group.
Hmm.
Lordship will see, we have scored 901, response number 8 has scored 901. Where 2 or more candidates secure equal aggregate marks, the tie is resolved in accordance with the following principles. Candidates securing more marks in compulsory papers and, my lord, integral personality tests put together, my lord, is to be ranked higher. Now we have to see what is the compulsory subject here, my lord. The compulsory subject here for both the parties is general English and general studies paper, my lord. Now, both the marks of general, Lordship kindly adds, my lord. General studies, my lord, I have got 149. And general English, I have got 196, which makes my score.
513.
Yes, and including Viva voice 168, it comes to 513. And now my lord will come to the response number 8. In his general studies paper, he has scored 180 plus 130, and my lord 145. It comes to 455. I am above him. I have scored more than him. And as per rule 68A, I should have been ranked higher, my lord. And instead, my lord, he has been selected, my lord.
What are the compulsory papers?
My lord, compulsory papers are general English. Now, my lord, that will be showcased, my lord. Kindly, to come to the writ petition first, my lord, at page 29. I will showcase first the optional subjects, and I will also showcase the compulsory papers. Page 29 is the of the writ petition is the, that is the, my lord, the advertisement itself, my lord, which my lord, which showcase. You will also got 6-2 main examination, page 29. My lord will come to the bottom thing, my lord. Written examination will consist of the following papers of 3 hours duration each. The questions of the examinations will be conventional essay type, my lord. My lordship sees, my lord, general English and general studies first. That is 300 marks. And after that, my lord, optional paper 1, optional paper 2. So he has to, the candidate has to select those 2. And then, my lord, the Viva voice marks is counted. And then total is. Now, my lord, if your lordship comes below that, there's a list of optional subjects for CC mains total. There are 29 subjects, my lord. Lordship sees 29 subjects. 29 subjects. Now, my lord will kindly see animal husbandry and veterinary science. Now, lordship kindly reverts back to the affidavit filed by the APSC yesterday. They have given veterinary science 1, veterinary science 2. That is an optional subject. So they cannot count that. It is an optional subject. Then, my lord, your lordship will see education. Education, I have selected that. That is the petitioner. Education 1, education 2. That cannot be counted. That's optional. Then, my lord, political science, his subject, my lord. Political science 1, political science 2. This is optional. Then, my lord, last, my lord, sociology. Sociology also, my lord, is there, my lord, in the option, in the list of options. So it means these are all optional subjects. Now, my lord, I will produce My lord, the APSC rules itself. The earlier rules, my lord, the same rules, my lord. Lordship will kindly have a look at this rule, my lord. It's very crucial. This rules, my lord. The same APSC, my lord. So Lordship comes to the third page, my lord.
What is this?
This is the APSC rules, my lord, and regulations. It's rules and regulations, my lord. The Lordship comes directly to the third page, which I have annexed it, my lord. Third page, Lordship sees at point number 3. The main examination will consist of written examination and interview test. The written examination will consist of 2 compulsory papers on general English and general subjects, my lord, study subjects. So general studies and general English, my lord, prima facie is the compulsory paper. Now, as per rule 68A,
So these rules are still in force?
my lord, yes, my lord, because this is part of the, my lord, 2010 rules. And my lordship will kindly see the advertisement once. Kindly see the advertisement at page 29 of the main advertisement. The main advertisement itself will say, my lord, the list of optional subjects for CC mains. Kindly come to page 29 again. Lordship will see, Lordship can tally. First, my lord, there is and the third is thing, animal husbandry and veterinary science. That is the, my lord, the optional subjects for the respond number 8. He has taken veterinary science 1 and veterinary science 2. Then education, my lord, I have taken education, my lord, as my optional subject. That is also, my lord, optional subject number 1 and optional subject number 2. Then, my lord, political science he has taken, my lord. That also is political science 1. That's optional, my lord. Then sociology also same. I have taken, my lord. These are all optionals, my lord. Now, if your lordship again reads the rules, that is of 68, the main rules, my lord, which is at fourth, my lord. Rule 68A. Candidates securing more marks in compulsory papers and interview personality. So, my lord, I have scored 513 and he has scored 455. And they have given the marks, my lord, how much I've scored in the general studies and as well as how much he has scored. 180 plus 136 plus the Viva bus. And my lord, without taking interview also, if your lordship, if it takes B also 68B, then also we are more than him. We are 3-1. 149 plus 1.
Pursuant to the order passed by this court on 6/1/2026, the respondents numbers 1, 2, and 3 has filed an affidavit in opposition, has filed an additional affidavit. Bringing on record as to how Rule 68 of the Assam Public Service Commission bracket procedure and conduct of business bracket close rules 2010 have been applied. Full stop. Taking into account that a copy of the said affidavit is not on record, comma, list this matter again on (21) 2026 as the first item. Liberty given to both the petitioner as well as the respondent number 8 to file additional pleadings if so advised.
Much
The
obliged.
registry shall bring on record the said affidavit, additional affidavit filed by the respondent numbers 1, 2, and 3.
Much obliged.
Mister, you file it because I'm giving you this opportunity because you are kept it there in the dark. Yes, Mr. Khan. What is this?
Hearing
You,
was put that unfit on the ground.
while taking a bench for, there is a matter called the site visit cases, where Mr. S. Hawk, Lalit Council, seem to have expertise. You seem to have expertise in this type of matters. This is the fourth matter. Same? Unfit? Unfit case.
Unfit case. But in here, your lordship is 31, your lordship kindly see. Is 31, your lordship kindly see.
Ah. Okay,
It was
same
done
order.
By them, your lordship, but as per the guideline, your lordship. Slide. Estimating is permissible here. If the estimate appears after 4-5 sentences, then it is permissible. But if there's 31, your lordship, it is.
Same order. I can't look into all this. You have not enclosed the guidelines. Where is the guidelines?
The guideline,
Where is it?
I'm reading your lordship.
No, no, don't read. Same order.
So
Disposed.
in here given,
Disposed. 10 days. File your affidavit. I've passed in all these orders, directing them to complete the, if you submit your representation within 10 days, within 60 days, the RME will look into it.
Lordship, here it was found that he is suffering from mild stammering by the other doctor also. And our guideline says that stammering is a general ground of rejection, that I have given the instruction, Lordship.
But there is some certificate to that effect.
That is also showed mild stammering. And we found him is stammering, and our guidelines says
Mild stammering is different, na? So I'm not deciding anything. I'm asking him to submit a representation, giving all these particulars out there. And you will decide if he submits within 10 days, you decide within 60 days. You settle your disputes between you and him together. Go there.
27.
What is this?
Their candidature was rejected.
Ah.
Non-submitting NC.
Because of non-submitting of OBC NCL certificate as on 14/10/2024.
OBC NCL certificate. Okay. Yesterday I was supposed to dismiss somebody's case, his case. I started today itself. He said there are similar matters which are there on 9-1.
Yes, there are some other matters which are fixed on.
What do you want? That this court should direct you that to submit a certificate later on?
But if there is a problem with the residents or the candidates who are residing in the district of West Karbi Anglong. Those who are residing in the district of West Karbi Anglong, there is a difficulty for them to obtain the certificate as on 14/10/2024. Because of the fact that these petitioners, lordship, they reside in the district of West Karbi Anglong. In February 2024, the Karbi Anglong Autonomous Council had issued a notification directing for eviction of 11,600 acres of land. These petitioners, they reside within that particular area. Your lordship had stayed that eviction order.
I am not.
In a different petition. Now, in view of that notification, lordship, they were not allowed to apply for issuance of that certificate. Because for the candidates to obtain NCL certificate, OBC certificate, they are required to get an income certificate from the Assistant Revenue Officer first. Now, they were not allowed to apply because they were non-tribal residents who were residing in that particular permanent grazing reserve. And therefore, they could not get the certificates as on 14/10/2024. And this is one aspect.
How did you get the certificate? Then? How did you get the certificate? Where is the certificate? Where is the certificate?
Lordship, page 28.
Now, this is a caste certificate.
Yes.
Where is the NCL certificate?
NCL certificate, they could not get it.
Then without the NCL, you cannot.
Not
Matter over. You are to submit it. The last date, if I'm not wrong, is 10/2024. So you still don't possess the certificate. What is wrong? Level.
Now,
No,
Your Lordship, may kindly see
Mr.
based on the-
Yesterday I was supposed to dismiss one case. I didn't get the time.
Lordship, may kindly
My
see the-
satisfaction.
Lordship, may kindly
Today
see
I am
the-
dismissing your case.
Page number 35 for a moment.
Here is, what is that?
Lordship, there are clauses prescribed in the advertisement.
Ah,
Clause 6.1, Your Lordship, may kindly see.
ah.
May I read, Lordship? Candidates who wish to be considered against reserved vacancies or seek age relaxation are required to submit the requisite certificate from the competent authority in the prescribed format. When such certificates are sought by the CFS concerned for document verification at the time of DME. Otherwise, their claim for SC, ST, OBC, EWS, ESM category will not be entertained, and their candidature applications will be considered under the unreserved category. Now, once they fail to submit the relevant certificate in which the candidate claims his category, his candidature will be treated as unreserved. Therefore, these petitioners, even assuming that they fail to submit the requisite certificate, their candidature cannot be straight away rejected.
But what do you say about 6.5?
6.5 says that the crucial date for claiming OBC is 1410.
1410. So as on 1410, you have to have a certificate. As of now, you don't have a certificate.
No, the difficulty is that 6.1, now your lordship may kindly see page 36, 6.8. Candidates may also note that in respect of the above, their candidature will remain provisional till the veracity of the document concerned is verified by the competent authority. Now, therefore, they cannot straightaway reject my candidature.
No, rightly rejected. You
Because-
the,
because
you have
by-
not, no.
Because in view of.
Candidates
6.1
who wish to be considered against reserved vacancies or age relaxation are required to submit the requisite certificates from the competent in the prescribed format when such certificates are sought by the CAF concerned for document verification at the time of DME. What is DME?
detailed medical
Examination. Otherwise, their claim for SC will not be entertained and the candidature application will be considered under unreserved.
category.
Further,
Therefore,
if the
lordship,
candidate has sought any age relaxation or claim remand and is not able to procure the relevant certificate, he will be considered in his respective category so and so. The formats of the certificates are enclosed. A candidate belonging, so this is process of certificate and format of certificate. Now, when this certificate, is this certificate required to be submitted at that point of time? When, what?
No, a specific format. is
No,
provided.
this rejection is at what time? Page 106.
On 29/11/2020.
No, that I understand. On what basis? What is this point? At what point of time this has happened?
During the document verification.
So as of now, you don't have that certificate?
So we have that certificate.
Where is that?
The NCL certificate we do not have.
Matter over, what is there? Heard Mr. R.
Lordship may
Bora,
kindly- Lordship may kindly-
heard
Yeah,
Mr.
yeah,
Div- Division Bench, heard
Lordship-
Mr. R.
Lordship,
Bora,
there
the
are other
learned
matters which are
counsel
please-
appearing on
Lordship may
behalf.
kindly take this matter along with.
No. Today, tomorrow I say similar matter and he
Yes,
just.
it is Similar matter, Lordship.
So therefore tomorrow, today being a Thursday, it will be a bit longer. Tomorrow it may be a shorter. So I'm doing the work for today itself.
Lordship,
Heard Mr. R.
Lordship
Bora.
may
No,
kindly
no,
fix it
no,
to
Mr.
719.
No, Mr. Bora. I'm yet to sign that earlier order, na? That order also is there.
Lordship
Heard
may
Mr.
kindly-
R. Bora, the learned
Lordship may
counsel
kindly
for the
consider.
petitioner. And Mr. S.S. Roy, the learned counsel who appears on behalf of the respondent numbers 1 to 7. And Mr. T.C. Sutia, who appears on behalf of the respondent number 8.
Lordship, it is because of the administrative delay, Lordship. because
Can't
the
help it.
Petitioners could not obtain the certificate. Lordship, there is a Supreme Court judgment in fact in my favor, in favor of the.
The division bench, let it help it.
So Lordship may kindly fix.
The
it
present writ
tomorrow.
petition has been filed seeking a writ in the nature of certiorari challenging the impugned rejection slips dated 29/11/2025 issued by the respondent number 7 and further seeking a direction upon the respondent authorities to consider the candidature of the petitioner under the OBC non-creamy layers category after making necessary verification with the District Commissioner West Karbi Anglong, if required, and further direct the respondents to do the needful to appoint the petitioner if found fit in medical examination and meritorious. Full stop.
That's it.
The facts of the instant case which arises is that on 5/9/2024, an advertisement was issued for recruitment to the post of Constable GD in the Central Armed Public Police Forces bracket CAPFS bracket close and SSF, Rifleman GD in the Assam Rifles and Sepoy in Narcotics Control Bureau Examination 2025. In the said advertisement, the various dates have been mentioned. Full stop. For the purpose of submission of the online application form, the window open was from 5/9/2004 to 11/10/2024, 5/9/2024 to 11/10/2024. It is also categorically mentioned that the last date and time for receipt of online application form is on 14/10/2024 on or before 3 p.m. Full stop.
On or before 2300 hours.
Huh?
2300, 11 p.m. up to 23 hours.
Or last date, no, that is for, or 2300.
23.
3 p.m. no, 2300 hours, 11 p.m. on or before 11 p.m. Full stop. The petitioners herein, who admittedly belong to the other backward classes category, applied in pursuance to the said advertisement to the post of Constable GD. Full stop. Clause 5 of the advertisement stipulated the age limit. The age of the candidate must be 18-23 years as on 1/1/2025. That is, candidates born not before 2/1/2002 and not later than 1/1/2007. However, in respect to certain categories of candidates, the advertisement further prescribes age relaxation. In the case of SC/ST, the age relaxation is 5 years and OBC is 3 years. Full stop. Where is it mentioned that there is a requirement of NCL certificate?
No, that is not there. They provide a specific format of Annexure 7 that is also will find.
Clause 6 of the advertisement stipulated the process of certification and the format of certificates.
Page 93.
Full stop. In terms with clause 6.1, the candidates who wish to be considered against reserved vacancies or seek age relaxations are required to submit the requisite certificate from the competent authority in the prescribed format when such certificates are sought by the CAPFs concerned for document verification at the time of DME. Full stop. It is further mentioned in the said clause itself that if such such requisite certificates are not produced, the claim of the candidate for SC, ST, OBC, EWS, ESM category would not be entertained, and their candidature / application would be considered under the unreserved category. Further to that, the said clause also mandates that if the candidate have sought any other age relaxation or claimed ESM status and is not able to produce the relevant certificate, he would be considered in his respective category SC, ST, OBC, EWR, EWS, UR. The formats of the certificate have also been provided in the said notice with the notice of the examination. Full stop. Where is the format?
Page 93 document. There is only one format as Annex 7, which says that only OBC certificate has to be produced, not NCA.
There is.
Mr. Roy, why do you say about this
It is
OBC
there.
certificate has to be as per NCL?
Yes, Lordship, that the last part, Lordship, this is also to certify that she does not belong to the person section creamy layer mentioned in column 3 of the schedule of the Government of India Department of Personnel.
Where?
Last paragraph, Lordship,
Of?
of that page 93. Column
The certificate for other backward classes is at annexure Roman 7 to the notice of examination. To the notice. Full stop. The contents of the said certificate being relevant is reproduced hereinunder. From a perusal at page 93. From a perusal of the format provided in annexure Roman 7, it is seen that to be eligible to apply in the category of other backward classes, the certificate should also contain that the candidate does not belong to persons / sections creamy layer as mentioned in column 3 of the schedule to the Government of India Department of Personnel and Training OM number 36012/22/93 ESTT SCT dated 8/9/1993. This court also finds it pertinent to take note of another very relevant aspect, which is clause 6.5, which stipulates that a crucial date for a claim of SC/ST/OBC/EWS status or any other benefit, viz. fee concession, reservation, age relaxation, etc., would be the closing date for receipt of the online application form, that is 14/10/2024. Full stop. In the backdrop of the above, the materials on record would further show that though the three petitioners herein had applied for the post of Constable GD, but did not have the OBC certificate, as is required in terms with Annexure Roman 7 to the notice dated 5/9/2024. Full stop. The resultant effect is, at the time of document verification, such certificate could not be produced, and consequently, the candidature of all the three petitioners were rejected by separate rejection slips, all dated 29/11/2025. Full stop. A perusal of the rejection slips, which have been collectively enclosed as Annexure D Colli, reveals that all the three petitioners are overaged and they cannot be considered to be entitled to any age relaxation as stipulated in clause 5.1 of the notice dated 5/9/2024, on the ground that the petitioners have failed to produce the certificate in terms with Annexure Roman 7 as reproduced herein above. It is under such circumstances the petitioners have approached this court, challenging those rejection slips and further seeking the directions as already mentioned herein above. This court have duly heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. From the perusal of the materials on record, it is an admitted fact that the petitioners as on date also do not have a certificate, have certificates in terms with Annexure Roman 7 of Annexure Roman 7, which mandates that the said certificate should certify that the petitioners, apart from belonging to the OBC category, is also belongs to the non-creamy layer.
Lordship, as on date, they have those certificates. I have not annexed those certificates. Lordship may fix this matter tomorrow. I can
Okay.
produce them.
That as on the date on what verification? Did you have it as on the date of verification?
No, because there is a notification that is substitution.
The materials on records show that the petitioners have not enclosed, have not submitted the certificates in terms with Annexure Roman 7 or have produced such certificates at the time of document verification, which is the mandate of clause 6.1 of the notice dated 5/9/2024. Further to that, the advertisement, the notice dated 5/9/2024 makes it very clear that the closing date is on 14/10/2024. Full stop. Under such circumstances, it is the opinion of this court that the rejection of the candidatures of the petitioners cannot be said to be illegal, arbitrary, or in violation to the guidelines, violation to the terms and conditions mentioned in the notice dated 5/9/2024. In that view of the matter, this court does not find the present writ petition to be a fit case for issuance of notice, for which the writ petition stands dismissed.
There is a notification issued by the Staff Selection Commission in terms of the judgment passed by the Apex Court in Abdul Rashid versus Union of India, wherein the Staff Selection Commission itself, themselves, they are saying that they will accept a certificate of Annexure 7 or OBC NCL after 6 months of the stipulated cut-off date.
This was for the earlier examination, not for this.
I am giving you the road open now to show this, go to Supreme Court and get an order immediately. Yes.
For that bit.
May I please?
Ah, yes.
This will become getting appointment, denying my appointment because I have a criminal case pending against me along with my family members.
You are what? Appointed as here, what?
Some police, my lord, Constable UB.
And what criminal case is against you?
My lord, a family case.
Huh?
A family case given by the, my lord, my elder brother was married a woman, a girl. She filed a case against my elder brother along with my family member, along with me. my lord.
So that the case is very weak. That case?
Very weak, my lord.
Very well. Then why don't you go for quashing? Come for quashing and then file the writ petition.
Because appointment date is on the, my lord.
FIR, her name is there.
Look, it is crime, my lord.
As per advertisement manual, subject to satisfactory police verification. Now there is a provision where they have to submit an affidavit declaring that no criminal case is pending against me. That he has failed to produce this affidavit. That's why he is not allowed to join. That is the case. As per personnel department notification, every new appointee has to submit an affidavit declaring that no criminal case is pending against me.
What is your name?
Puspanjali,
Puspanjali, my lord.
page 42. In FIR page 42, Puspanjali name is serial number 4.
Page 37.
That is selected case, page 37.
Yes.
She is selected. No doubt.
Appointment, Nobazate Muslim.
So charge has also been framed against you.
Such submitted.
Same, that's section 353, 354.
323 and 354.
Yes, 354.
323 is what?
353 is my lord, injury. my lord.
What
Grievous
injury?
my lord.
Grievous?
Injury.
Grievous?
Injury.
Injury, there are many types, na? Simple or grievous?
For my lord, 353.
323 is what?
323,
What is that?
320. Voluntary causing grievous hurt. my lord.
So,
But in the medical report itself.
no, that I'm not there. I'm nothing to do with medical report. That is for the criminal court to look into it.
Right.
So, as regards, there is a charge being framed against you under 323. Second is under 354. 354 is what?
354 is my lord, against women, my lord, because I am also a woman. my lord.
Yeah, of the modesty of the woman, isn't it?
354. Assault or criminal force to women with intent to outrage our modesty. my lord.
Then you have a 34 along with it. What is 34?
34. All sections are my lord,
Common intention.
What is 34?
Common intention.
with common intention, my lord.
Common intention with what? Rape 376.
But I am woman, my lord. This one is-
So women cannot cause grievous hurt. I am asking you. Not possible.
But in the my lord, 161 statement itself, their eyewitness who said that we are not present at the moment of my lord incident. That is also an exception.
So what order can I pass? Tell me. You only tell me what order should I pass. Tell me. What do you want?
This will therefore we will call for my lord if necessary, my lord.
Read in the mandamus should not be issued, thereby directing her to consider the case of a beer and allow her to join in the said post, as there was no such rules by depriving her from the legal right while she is not the main accused. A bit difficult, don't you think? Huh? Yes. So I think you better fight it out internally than to bring the court in between. Don't you think? It would be very difficult. And the moment I dismiss it, it will give a stamp of approval for them to immediately reject your candidature.
Another thing, my lord, last.
The most important thing is this, that you should say that, okay, whatever may be, let me try my luck with these authorities. They may be good.
I approve even SP also, my lord. But
Because they have a big problem. They want an affidavit that you don't have any criminal case against you. And these are cases involving, what is that word you use? Moral turpitude. Huh?
Antecedent. Character and antecedent.
No, that is okay, but it's moral turpitude.
Moral.
So with moral turpitude, you cannot get it.
But I am not present at the place of occurrence as stated 161 statement.
So why have you not challenged the framing of the charge against you?
That I have some mistake with my mistake with communicate with that trial court.
Okay.
But now I am victim, my lord.
So doesn't your is your client not doesn't have the power to engage some other lawyer of challenging the charge?
Yes, my lord, that in quashing also I will try, but
So therefore, get it quashed. Once you get it quashed,
no,
then file a writ petition. Get it quashed and come and file a writ petition. I'm always here. But as of now, It's a case for dismissal.
My lord, last occasion, well, asked to instruct the.
I have received instruction, I have received
from
instruction,
the
that is the instruction.
Department. That's it, reflected, I will withdraw.
What?
Matter, I will withdraw the matter. Reflection of that instruction that due to non-filing of any affidavit. My lord, my.
You have the instruction?
That is the instruction, my lord.
Where's the
Just I
instruction?
have received, my lord, in a mobile, my lord.
Okay, get a,
Oh,
you have
yes.
got it, get a
Yes,
printout?
also kindly see page 36. There is
Get a printout?
Because there
Give it
is
to me.
no communication with us.
It's okay, get a printout, we'll record that and
Yes, yes, I will give you.
later on again, Mr. If you don't produce the instruction, I'll put it at X.
No, my lord, I have a instruction,
Then,
6th of January, my lord.
so, 6th of January, it is still waiting.
No, but today just when Simontoni Borwa she received, she is now in the doctor, my lord, he under treatment, my lord, she sent it, my lord, Simontoni Borwa, junior government advocate.
How did they,
She received the instruction,
who?
Simontoni Borwa, S. Borwa, my lord, our junior government advocate. She has gone to the doctors, my lord, today for some treatment. She sent it in the mobile, just I have to receive it. The
So give
slip
it
is
to
the-
them.
Oh, yes, yes, yes. Ashok Bhatti. A condition is there in the appointment letter also, page 36. There is a affidavit is required, one.
Page 30?
36.
No, but then also that is the reason why he wants to know what is the next course of action he has to do.
Yes.
Page?
Why?
36. As per recommendation, state level is equipment board so and so, so and so, so and so.
36, so
Employee
and so, as
candidates
per
are appointed
recommendation
to
of the
post-
so and so notarized affidavit submitted by the candidate as per so and so in the format therein regarding character and anticipate and subject to satisfactory verification of documents and undertaking submitted by so and so. Now, where is the affidavit required? What types are here? Here, do hereby solemnly, I voluntary and will do this, and I have solemnly affirm and declare that I satisfy all the qualifying criteria, and I have married a person who's a wife and living, and I also declare that I do not have more than a month, and I shall be summarily discharged. Therefore, the appointee shall submit notarized regarding the personal be department or format of the affidavit is enclosed.
In the advertisement also, page 34.
Hmm?
In the advertisement, page 34, also kindly see clause 12.
Final
Appointment
appointment
selection
after
subject to
selection is
satisfactory police
subject to
verification report and
satisfactory
final
Iman and
verification.
Minel as per Iman. In case AI is or final AI is found unsatisfactory, the candidate will be rejected. Vale. লেখক তো আহি পাই মানে মই এইটো ডিক্টেশ্যন দি দিওঁ Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. T.C. Sutia, the learned additional senior government advocate who appears on behalf of the respondents. The petition, respondent numbers 1 to 6.
7 is a private respondent.
Respond numbers 1 to 6. Taking into account the order which this court proposes to pass, this court dispenses with the service of notice upon the respondent number 7. First, the grievance of the petitioner herein is that the petitioner have been selected
And page 36,
as a constable
UB.
UB
Will be constable.
by the and duly intimated on the basis of a communication dated and duly intimated
2nd December.
on the basis of a communication dated 2/12/2025. The grievance of the petitioner herein that in spite of the said communication being issued and the petitioner having submitted the necessary documents, the formal appointment order had not been issued to the petitioner. It is under such circumstances the petitioner has approached this court. Appointment order has been issued or not?
He is not allowed to join only.
Look, in spite of had been no, Nikhil,
Yes, 36
it
months.
is the case of the petitioner that by the communication dated 2nd of December 2025, the petitioner as well as various other persons have been appointed as Constable UB. What is the name of the petitioner?
Anapanjali, hello,
Serial number?
1352. Middle page 37.
Page 37, Puspanjali. Yeah. In terms with the said communication, the petitioner has been further posted at Nalbari DEF. The grievance of the petitioner herein is that the respondent authorities have not permitted the petitioner to join. And as such, the present writ petition has been filed. It is seen that when the writ petition was first moved before this court directed the state respondents to obtain instructions and apprise this court on the next date as to why the petitioner have not been permitted to join. In pursuance thereto, the matter has been listed today. Mr. T.C. Sotia, the learned additional senior government advocate, have placed before this court an instruction issued by the senior superintendent of police, Nalbari, Assam, dated 6th of January 2026. The said document, the said communication, instruction, dated 6th of January 2026 is accompanied by various other documents which are all collectively kept on record and marked with the letter X. In terms with the said instructions, it is seen that upon carrying out the police verification of the petitioner in respect to her character and antecedents, it came into light that the petitioner is involved in a criminal case registered under Belsor PS case number 1/2025, registered under section 376, 384, 325, 354, 34 of the Indian Penal Code, which have been charge sheeted by charge sheet number 15/2024 dated 24/2/2024. The Belsor case has to be earlier, na?
Earlier,
Eto dipode date hobo. Again re-registered. Earlier it was different case or what? Huh? Belsor case actually is, should have been 283.
This is police case, my lord,
Uh,
and session case 26.
This is 2025.
It is also mentioned that the case is presently under trial before the learned court of the session judge Nalbari. The instructions further show that the petitioner have not been able to furnish the required affidavit. With self-declaration regarding non-involvement in any criminal case. And as such, the petitioner's joining process could not be completed. It is further mentioned that the petitioner have also been informed verbally full stop. The learned counsel appearing on behalf of the petitioner submitted that taking into account the said instructions, which is kept on record and marked with the letter X, the petitioner would not like to press the instant writ petition. However, in the circumstance, the criminal case which have been, the criminal proceedings against the petitioner is quashed or the petitioner is acquitted, the withdrawal of the instant petition should not prejudice the petitioner. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. Liberty, however, is given. Withdrawal, full stop. It is further observed that in the circumstance the petitioner's, the criminal proceedings against the petitioner is quashed or the petitioner is acquitted, the withdrawal of the instant writ petition shall not prejudice the petitioner. You have a copy of this or not? Take a copy, he will give it. Yes, what is this, Mr. D?
Maybe the trade law. Either will of petitioner because lawsuit will the assistant.
What?
Assistant enforcement inspector.
Similar prayer?
Prayer will of inspector. Can be considered his case for promotion. What had happened, Milord? Earlier in the 2003 rules, there were two conditions. One was 10 years of service and maximum age limit was 50. Initially, I filed an application at the verge of 50. I filed an application for consideration of.
Consider the case for promotion of the petitioner to the next higher post of enforcement in
The
view
last
of the
25 years,
assignment.
Milord, I'm in this post.
Huh?
For the last 25 years, Milord, because of that bar, age bar. And in fact, Milord, the age bar has been Milord, relaxed in 2025. And because of the pendency of the repetitions, Milord, at that point of time, Milord, my case was not considered. So in
Now
fact,
what do you want?
Milord, only thing, Milord, my case should be considered because of this, because of the recent amendment in 2025.
Where is that?
So I'll just place it. In fact, I quoted it at page, the original, the initial was at page 6, Milord.
Page?
6. This was the earlier one. That is the, this is the 2003 rules. Milord.
You are an assistant enforcement inspector.
Yes, ma'am.
You want to be an enforcement
Yes.
inspector.
In fact,
Now where are the rules?
the rules, Milord, This is what is quoted below. Now, the.
Mr.
required-
Day, did
know-
you think that your repetition is such horrendous case that there is no chance of you to gain any order for which you have not enclosed the rules?
Rules, these are the rules are otherwise, I'll just write in place.
Give it. How will this court know? What is the rule?
Quoted the relevant part below.
Okay, now what is it?
Lordship will kindly come to.
You are an assistant inspector, enforcement inspector to enforcement inspector.
Yes, madam.
Subject to suitability as may be decided by the board and appointing authority in so and so, vacancies to the kinds of joint commissioners, so and so, so and so. Extend in so and so, subject possessing the experience as prescribed in 2, 3, 4, 5, 6, and 7. From assistant inspector to so and so, it is there. Now, what is the age problem?
1161, madam.
Huh?
1161, Lordship will kindly.
6-1. A member of the service in the cadre of assistant EA who have not completed 50 years of age and rendered 10 years of service in the cadre on the first day of the year in which the selection for promotion is made shall become eligible for. So you have crossed 50 years.
Yes, prior to crossing the load, I filed an application.
Huh?
Prior to crossing the age bar below, I filed an application for consideration. That was not being disposed of. I approached this honorable court by challenging that particular rule. Since the MSCP scheme was being given to me, I had to withdraw the case.
You got MSCP.
Yes, I was getting an MSCP.
Now what happened?
Now, Lordship, thereafter, my lord, I came to the
The
court for the
words
second
not
time.
completed 30, 50 years of age appearing here and who have and rendered shall be deleted. So 50 years is not there.
As of now, that.
Not there. So now you can be considered.
But I think that is that, my lord, only because.
Lordship, this is the fourth round of litigation, my lord.
Let us not make it the fifth or give him more urgency to go to the fifth.
Lordship, may kindly have a look, page 31. The order of the Honorable Division Bench of the Honorable Court.
There is there, my lord. In that point of time, my lord, the 50 age bar was there.
Lordship, the from third.
Page
paragraph.
31.
Lordship, from third paragraph, may I read, my lord? May I read, my lord? In this regard, MS Bora Standing Council has submitted that the practitioner, however, have been given financial upgradation under Assured Career Progression Scheme in view of the lack of promotional avenues. We are of the view that if promotional avenues are not available and the benefits under SCPS are given, they would mitigate the expectation for higher promotion. Then he withdrew the case, not raised the case, my lord. It was closed. Again, he filed another writ petition before this honorable court and it was dismissed.
Madam, the question is,
Lordship.
here he challenged 1161.
Yes,
Now there, the question was, the issue involved is as regards the legality and validity of clause 11.6, rule 1161.
yes, my lord.
And there you submitted the look here, the petitioner is getting the MACP or SCP, whatever may be, and as
Yes.
such, he says that as I am getting, I forget it, I'm not.
Financial
getting it.
benefits,
Now, in the meantime,
my lord.
this amendment has come in.
Lordship.
With the amendment coming in,
Lordship.
now he has a right to be considered.
Yes, my lord.
So he is only asking that in view of the amendment, his case should be considered as per the rules.
Yes, Lordship. My lord may dispose of the matter, in fact.
That is why I think.
If he is under the zone of consideration, he is otherwise eligible, we will consider when the other person will be considered because
He
we
will
have not
consider
annexed
as
any
per law.
gradation list. Yes,
Required, my lord, I'll file a fresh representation. If required, I'll file a fresh representation, my lord.
What is there to representation? They will consider
Lordship,
your
yes.
case.
Lordship.
Whenever
eligible,
they
my lord.
go for recruitment
Lordship.
to the
Promotion.
post of enforcement inspector, the case of the petitioner would be
Considered.
taking into account that the petitioner now has a right to be considered, which is
Considered.
a fundamental
Yes.
right.
Lordship.
That is the.
Lekhok. Heard Mr. R. Day, the learned counsel appearing on behalf of the petitioner, and Miss M. D. Bora, the learned standing counsel, Transport Department.
For all the respondent.
For
all the
all the
respondents.
respondents. The case of the petitioner herein, the petitioner by way of the present writ petition have sought for directions that the petitioner's case now be considered for the post of enforcement inspector in view of the amendment made to Rule 11 bracket 6 bracket small 1 of the Assam Transport Service Rules 2003 by the Assam Transport Service Amendment Rules 2025. First, it is the case of the petitioner that the petitioner was appointed as an assistant transport officer, enforcement inspector on 1/7/2000, and his service was regularized on 10/7/2000. Isn't it?
Yes.
Good stuff. When the petitioner's turn came for promotion, to be considered for promotion to the post of enforcement inspector, his case was not considered in view of Rule 11 bracket 6 bracket 1 small 1 of the Rules of 2003, inasmuch as the petitioner was above 50 years at that relevant point of time. This resulted in challenging Rule 11 bracket 6 bracket Roman 1 of the Rules of 2003 by the petitioner. However, the said challenge the said challenge was withdrawn by the petitioner, as the petitioner in the meantime have been given the benefits of the, what is that, MACP?
Modified career.
Modified hetu likhi dilu.
Also, I have the scheme.
No, it's okay. Okay. Good stuff. Be it as it may, by the notification dated 5/2/2025, the Assam Transport Service bracket Amendment Rules 2025, for short the amending rules of 2025, was notified, whereby Rule 11 bracket 6 bracket 1 of the Rules of 2003 was amended, thereby deleting the words and figures, inverted comma, not completed 50 years of age and, inverted comma, close. Good stuff. The resultant effect of the said deletion is that an assistant enforcement inspector who is above the age of 50 can still be considered for the post of, for promotion to the post of enforcement inspector. Next. The grievance of the petitioner is that the petitioner's case had not yet been considered, and as such, the petitioner has approached this court. Ms. M.D. Bora, the learned counsel, standing counsel of the Transport Department, submits that the rules of 2003 mandates as to when the recruitment process for promotion by promotion would be initiated. The Learned Standing Council submitted that when, as per the rules of 2013, the posts in the cadre of enforcement inspector is vacant, the respondent authorities shall duly consider the case of the petitioner. Taking into account the above, it is therefore the opinion of this court, taking into account this court have duly heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to the materials on record. The right to be considered for promotion is a fundamental right. Under such circumstances, in view of the amendment carried out to Rule 11 bracket 6 bracket 1 of the rules of 2003 by the amending rules of 2005, 25. There is now no embargo upon the respondent authorities not to consider the case of the petitioners upon when vacancy arises to the post of enforcement inspector. Accordingly, this court therefore disposes of the instant writ petition with a direction upon the respondent authorities to consider the case of the petitioner along with other eligible assistant enforcement inspectors for promotion to the post of enforcement inspector when vacancy arises in the post of enforcement inspector.
Lordship, my lord, obliged, lordship.
Protection against conceal, same like the other matter. Only prayer is that these matters may be taken up tomorrow, lordship, since similar matters are already before the lordship. 31, 33, 34, 39, and 41. Thirty, 31, 33, 34, 39, and 41.
This non-creamy layer certificate is given every year.
For 1 year, valid for 1 year.
Valid for 1 year.
Yes.
When did you apply for this application for that 2024 one, Annexure C?
This is dated 26/12/2024.
When did you apply? That is the date of your application.
Yes, Lord.
Why did you apply
is
so
for-
late?
That is for the NCL certificate, Lord.
NCL certificate only. Why did you apply late?
Yesterday I asked this petitioner, this particular petitioner, he said that he did not know about this, that he had to, later on he came to know that he has to submit this at the time of DM. So the moment he came to know about this, he applied, Lordship. Otherwise, at the time of filling the application form, they have to submit the OBC certificate. That he had submitted. But regarding NCL, this is done at the time of DM. After he cleared PST, PET, written everything. At the time of DME, document verification happens. And at that point of time, NCL is required to be submitted also for age relaxation. Now, when he had to submit NCL certificate, he went to the district commissioner. That kindly give me a certificate on regarding backdated certificates. Deputy Commissioner said that we cannot give you backdated certificate. Instead, they gave a letter, common letter, wherein the petitioner name also appears. I think that he belongs to OBC NCL for the year 2024 and 25, which also includes the crucial date. That your lordship will find at page 34. This is a letter dated 28/11/2025, prior to my rejection, lordship. To the presiding officer, recruitment of Constable GT exam, CAPF, BSF Patgaon, issued by the District Commissioner, Bongaigaon. Here my name appears at serial number 6, Sri Pankaj Rai, son of Sri Satsing Rai. Also my roll number, lordship. This is the subject is regarding submission of Annexure 7 OBC NCL candidates appearing for SSC GT.
So when you apply immediately on that date, they give you this letter.
Lordship. Had I applied before 24/10, I would have got my NCL certificate then. Lordship. But he did not know about this, lordship. 10 pass candidate, lordship. They hardly know how to read the advertisement also.
And you want to be a constable.
Constable, there is duty. is to
Constable, what is the basic educational
10
qualification?
pass, lordship.
Then why you are not challenging that 1610?
Lordship.
You see, why you are not challenging clause 6.5?
I have already participated in the recruitment process, lordship. I have cleared my written, I have cleared my PST, PET. Now if I go and challenge this, lordship. I ought to have done it.
Now, if you don't challenge 6.5 remains, then how do I exercise my jurisdiction then?
If that is true, only I am praying that, Lord, I am asking a question to myself, Lord. I do not have that certificate before 14/10/2024. Do I lose my NCL status, Lordship? This letter by the district commissioner, it reiterates the fact.
No, it is, you lose, you see, why I am giving an importance in this matter, not yesterday's matter. You see, yesterday's matter was you obtained the certificate on 3/7.
Lordship.
That is beyond that period, it is every year.
Every year.
It's not financial year, I suppose.
Lordship.
Lordship.
It is every year. So it will from 1st of January to 31st of December.
From the date of issuance, it was. From the date of issue, lordship. The certificate is valid for 1 year from the date of issue.
No, that not I am saying that. So a certificate is valid for that period. Now you didn't have a certificate prior to that.
I had for 2022, but not for 2024.
22 you had
Yes,
and
Lordship.
23. It is not that it is not creamy layer is, what is this concept of non-creamy layer?
Non-familiar came from this notification of 1993 from Mondal's commission that OBC candidates who will have non-familiar certificate will only be entitled
On age relation.
regarding the.
Yeah, that I understand, but what is a non-creamy layer?
Whose income is below 8 lakhs rupees, annual income, Lordship.
So
As
for
per
that period, it
2018.
may have been more also.
Lordship.
It may have been more also because the income is looked into every year,
Every
financial year.
Lordship.
So that is why I'm saying,
Lordship.
if it is a financial year is the question,
Yes, Lordship.
non-creamy layer is based upon a financial year is concerned. So this certificate can very well be looked into as it has been issued in the year 2024.
Lordship.
But the second certificate, which is of 3/7, it cannot be because it is a different financial year.
Sadhu.
But without a challenge to, because you have a good case for challenging rule 6.5 because your age is to be calculated as on 1/1/2005.
25.
25.
25. So that is the age how it is to be calculated. The educational qualification is to be calculated as on 1/1/2025. Then why they have put it at on 1410? It makes no sense. Obviously, this particular at annexure A can't be taken, annexure B can't be taken into consideration. This is a different financial year. Or is the non-creamy layer certificate based upon the financial year, the previous financial year?
পয়সা এইটো arbitrary হয় তাতৰ সংখ্যা। Same হয় methodically.
Now, Mr. Dekar, help me out. I want to help you out, but the fact remains, how do I help you out? How do I help you out?
Lordship, may I place a judgment of the division bench of Delhi High Court, Lordship?
Ah.
It's a judgment, Lordship. It's a very long judgment, Lordship, from the conclusion part.
There are 74 overall.
75.3, Lordship,
Again, you see, the rule has been challenged.
Yes.
in one of the methods there.
No, that is why it is being held. We hold so. The power to stipulate the eligibility criteria is not unlimited and can be exercised in an arbitrary manner held in so and so. Under Article 4 is not certified. OPCL AR certificate hold validity for a year and petitioner having herein have furnished AR for the relevant year of examination. Though the stipulated date for the date of AR falls in between the financial year, however, as held in the year, the cutoff period must correspond to the financial year. That is what I am saying. Now, how do I exercise my jurisdiction without a challenge to clause 6.5?
See, Judge, this one case was there of Honorable Supreme Court of India Lordship. If I may place Lordship, where the issue was Lordship, where the Lordship, the question of law that was decided was whether a candidate who appears in an examination under the OBC category and submits the certificate after the last date mentioned in the advertisement is eligible for selection to the post under the OBC category or not. That question was decided. 2016 4 SCC 752 Lordship. Ram Kumar Gijroya.
2016.
2016 4 SCC.
Because otherwise, as per clause 6.1, Mr. Dekar,
6.1.
as per 6.1, you meet it.
Lordship.
As per clause 6.1, you meet the criteria because as on that
Yes.
date, you had the certificate. Is only because of 6.5.
6.5.
Now, 6.5, you see that otherwise, they have put the age as on 1/1/2005.
1/1/2000.
They have put the educational qualification as on 1/1/2025. Means if you can have a much higher educational qualification, that can be looked into. But seems to be no justification as regards 14/10/2025 being the cutoff there. Whereas 6.1 says you are to produce at the time that you had you are not required to enclose that certificate at that point of time. So unless you challenge 6.5, how do I take care of it? That is my only issue. Here is also 6.5 or similar clause, it has been held to be arbitrary. What to do? If you don't help this court, how do I help you? Isn't it, Mr. Roy?
Not.
Give me some way out.
SCC.
Lordship, I was pressing a case for Honorable Supreme Court of India Lordship. Well, 17 होगा. अपना case.
Yes, which one?
Wherein at paragraph 3 Lordship.
Yeah.
Paragraph 3 Lordship. The important question of law to be decided in this appeals is whether a candidate who appears in an examination under the OBC category and submits the certificate after the last date mentioned in the advertisement is eligible for selection to the post under the OBC category or not. Your Lordship. Paragraph 16 at page 15 Lordship. Married Lordship. In our considered view, the decision rendered in the case of Pushpa Supra is in conformity with the position of law laid down by this court, which have been referred to Supra. The division bench of the High Court erred in reversing the judgment and order passed by the learned single judge without noticing the binding precedent on the question of law laid down by the constitution benches of this court in cases of Indrasoni and Valasama Paul Supra, wherein this court, after interpretation of Articles 14, 16, 15, 16, and 39A of the Directive Principles of State Policy, held that the object of providing reservation to SC, ST, and educationally and socially backward classes of the society is to remove inequality in public employment. As candidates belonging to these categories are unable to compete with the candidates belonging to the general category as a result of facing centuries of oppression and deprivation of opportunity. The constitutional concept of reservation envisages in the preamble of the Constitution as well as Articles 14, 15, 16, and 39A of the directive principles of state policy is to achieve the concept of giving equal opportunity to all sections of the society. The division bench thus erred in reversing the judgment and order passed by the learned single judge. Hence, the impugned judgment and order passed by the division bench in the latest patent appeal number so and so is not only erroneous but also suffers from error in law, as it is failed to follow the binding precedent of the judgments of this court in cases of Indraswamy and Balasama Paul Supra. Therefore, the impugned judgment and order passed by the division bench of the High Court is liable to be set aside and accordingly set aside. The judgment and order dated 24/10/2010 passed by the learned single judge in WPC so and so is hereby restored. So there, he was not selected because he submitted a certificate after the last date. After the last date of after the crucial date, and he was allowed to join us. But here, in my case, although I don't have a certificate in the format of Annexure 7,
Now, if we follow this judgment,
that's it.
the problem which arises is there is no end then.
It will be.
You don't submit at all because your age is dependent upon that. Otherwise, it is 23 years.
Yes, Lord.
Your age is 23 years. If you want to go for a relaxation of 3 years as an OBC candidate, very well. But for that, you need to have a certificate in terms with Annexure 7. Now, the fact remains that the Annexure 7 certificate, nowhere it is mentioned except in clause 6.5. The reason for holding, on one hand at 6.1, saying that this certificate has to be produced at the time when this verification is conducted.
DM, yes.
So this verification is conducted, you have this certificate of 2024. You had this certificate. But you didn't have this certificate prior to 24/10,
20,
which is the last date. Now, unless you say that this is completely unreasonable, how do I take care of it? My only question is this.
If I did not have a certificate certified by the competent authority, then I do not have a case, Lordship. What happened is at the time of DME, since he did not have the format, the certificate in that prescribed format, he approaches the district commissioner, the competent authority to issue an NCL certificate. Since the district commissioner said that I cannot issue backdated certificate.
Obviously, backdated, you shouldn't have applied.
So he gives a letter to the presiding officer, BSF camp, that this candidate belongs to NCL category. After going through his documents, this letter is issued by the office of the district commissioner, signed by the district commissioner himself of Bongaigaon district lordship, saying that I belong to NCL category, and as such, I may be allowed to participate in the remaining recruitment process, Lord. If your lordship for once goes to the letter.
I will look into it.
Yes, Lord.
This is the same letter which is there yesterday is also matter.
From
There's no
different
quarrel with
districts.
that.
This is. So if that letter can.
No, this financial year,
Yes,
you
Lord.
see, as you see, particularly the Delhi High Court judgment,
Lord.
it says about the financial year. So this financial year till 31/3/2025, it would have been valid at best. You may not have obtained then.
If it is from
The
March,
only problem is unless I hold that,
Lord.
how can I allow you? Because the moment I allow you to do so, I have to hold that to be arbitrary.
6.5.
Fixing the date as on 14/10 to be arbitrary. Don't you think that? As of now, it has already been rejected. So therefore, you need to challenge this clause.
Lordship, I'll withdraw the matter and then. I'll file.
You challenge this clause. Once you, because otherwise, this way or that way, you can very well make an alternative prayer also. You challenge the clause, then you give me on the Article 14 and 16 and take the benefit of what has been stated in here. I am in your favor, but you have to challenge that clause. Because as on the date on which the verification was carried out, unlike Mr. Arbora's case, he did not have that certificate then. You had the certificate on the date on which the year was carried out. So if you had the certificate on that date, obviously it was a certificate that day. You got two certificates thereafter.
Two certificates. One
So
from-
you had the certificate, but that certificate could not have been taken into had not been taken because of clause 6.5. So give me a handle somehow. Don't you think that? You withdraw with liberty. Because amendment would take some time. Better.
Take it out, bro. Just look all these methods, other methods also 31, 33, 34, 39, and 41.
Same.
Same, but
Everybody has a 24 also.
not everyone, some of them have. Lordship, I'll just take a chance, otherwise.
But these were before the decision.
Lordship,
These were before the decision. You say decision of rejection. These were before the decision of rejection, na? But then we can do something in that regard. Take up their grounds on it.
Lordship.
This one, I think you have a good case.
Lordship.
In this case,
Lordship.
he has a good case because that is for that financial year. But anyway, there also, if it can be done, we can issue a notice and then stay. Give a stay that particular thing to that effect. That is the only thing which can be done. But otherwise it will be difficult. Okay. Mr. D. Dekar, the learned counsel appearing on behalf of the petitioner submits that fixing the date, closing date of the certificate as on 24/10 or 14?
1410.
14/10/2024 by the respondents by the in the notice dated 5/9/2024 in terms with clause 6.5 is arbitrary and in violation of Article 14 and Article 16 of the Constitution. He further submits that a very perusal of the notice dated 5/9/2024 would reveal that the age as well as the educational qualification is counted as on 1/1/2025. But surprisingly, by clause 6.5, the closing date for the certificate has been mentioned as 14/10/2024. He therefore submits that the petitioner would be well advised to withdraw the instant writ petition with a liberty to refile by challenging clause 6.5 along with the rejection of the petitioner's candidature. So, taking into account the above, the instant writ petition stands closed on withdrawal. However, the withdrawal of the instant writ petition shall not prejudice or preclude the petitioner to file a fresh writ petition challenging clause 6.5 of the notice dated 5/9/2024, as well as clause as well as the rejection, impugned rejection of the petitioner's candidature. Same which other cases?
The cases were 31, 33, 34, 39, and 41.
SS Roy appears for the others.
I know this. Problem.
You take these.
Lordship, Mr. Borgia, the counsel for the petitioner, certainly feeling unwell due to his severe.
Can you hear what she is saying?
This petitioner is unwell, Lords, counsel is unwell, Lords.
Who?
Petitioner's counsel.
Petitioner's counsel. Who is the petitioner's counsel? NH Borbhuya.
Then the feeling unwell.
Hello, let us see what is the case about. What is the case about?
Compassionate appointment case, Lordship.
Huh?
Compassionate appointment case, Lordship, died in harness on 4/4/2002, Lordship.
When is your senior going to be well?
Lordship, due to severe diabetes.
Diabetes. Anyways, when? Diabetes is will remain till a person dies. Don't worry. Now tell me, when do you want?
Taken after vacation.
When? After vacation, month of December? When?
19.
19. At the request of the learned counsel for the petitioner, list the matter on 19/1/2026.
मतलब accordance to मतलब non-payment to मतलब corrected pension schedule.
Huh?
Petitioner husband was staff in the under the responsibility. They died in the US of life. Although well pension has been paid, man. Corrected pension was not paid to them.
Yes, what happened?
The lordship kindly pays the later pays 21.
As per your email, we are sending here with necessary data for correction of the family pension here. She has eligible for basic pension of remand in area salary of so and so, so and so. But as per your calculation, areas paid so and so. In area salary you from remand to remand. After pay revision of the pension, we have been revised old pension and rupees from month to month with effect from month and area pension of rupees. So and so. It should be revised from old pension from the month. We recommend to pay correct basic area.
This is the grievance of the petitioner, although it was later dated 23/2020. That was the letter of 2023, Malan.
Hmm?
That was the letter of 2023, Malan. Till Malan, after 2 years, Malan, the corrected pension has not been provided.
Now, what do you want?
I want Malan the corrected pension and the area amount, Malan. In terms of the letter dated 2023. To be paid to the board.
So as per this letter,
Malan. It is by the Malan senior most manager to the Malan head office. But the head office has not cleared it.
Mr. Sakya, it would have been proper on your part to make a brief summary of what is your case?
Only petitioner husband man, he was a sub staff man.
Who? Petitioner's husband.
Mohan Kapoor. He died, my lord, on 10/2/2025, my lord. Thereafter, my lord, he was paid pension
10 to 2025.
10/2/2005, my lord. By order dated 19/4/2007, pension was paid, man. Thereafter, the pension, since there was wrong in calculating pension, man, it was corrected, man. Corrected and the information given to the head office. The latest by this letter dated 23/2023, man. By that letter, man, it was informed that the corrected pension was, although corrected, but pension was.
So
not
in
released.
spite of that recommendation being made by the senior manager, you have not
Head
got,
office has not cleared.
they have not done it.
That is legal.
Okay. Issue notice making it returnable on 2nd of March 2026. Steps upon the respondent numbers 1 to 5 be taken by way of speed post. In addition to that, the petitioner is given the liberty to take steps upon the respondent number 4 by way of Dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the non-payment of the pension to which the family pension to which the petitioner is entitled to upon the demise, non-payment of the actual family pension to which the petitioner is entitled to upon the demise of her husband, as well as the arrears, of pension. Mr. P.J. Saikia, the learned counsel appearing on behalf of the petitioner, submitted that in fact the respondent number 4, who is the senior manager of the respondent bank, have also written a letter on 23/2/2023. But in spite of a passage of more than 2 years, the respondent authorities have not taken any steps. So being aggrieved, therefore, the petitioner, who is a family pensioner, is constrained to approach this court by filing the present petition. First, the respondents herein are directed to bring on record their stand by filing the affidavits on or before 21/22/2026. Liberty given to file reply by the petitioner upon the petitioner on or before 27/2/2026. On the next day, taking into account that the petitioner herein is a senior citizen, an attempt shall be made to dispose of the writ petition on the next date. I have given the ear to take by Dusty because it would act fast, but do it now. Okay.
Herein is a
Hey.
pension, Your Lordship.
Huh?
With 47 hours, Your Lordship, I have annexed some documents, Your Lordship. It shows that no abnormality has been found.
What is this pestus?
Tectus,
Huh?
excavatum, Your Lordship.
What is that disease?
Abnormal figure, Your Lordship. Abnormality in the chest. Abnormality in the chest, Your Lordship.
In the face?
Yes.
Chest.
But page 47 onwards, Your Lordship, these are the document
Same order. Can't look into it. Dispose.
37.
My lord, as a second wife, my lord, after the death of the first wife, my lord, paid for family pension, my lord.
You're the first wife.
Second wife, my lord, first wife, the expired, my lord, thereafter, my husband.
Second wife, Christian.
Lordship?
You're Christian.
No, my lord.
Hindu.
Hindu, my lord. After the death of the first wife,
Ah,
my husband married me.
second wife.
The second wife, my lord,
So
they
you
have-
actually are now the first wife.
Yes, my lord, first wife. Page 39, my lord. Page 39, everything is there, my lord.
Yes.
As per application received from Bharati Ramsiari, I hereby return back the both the halves of PPO in respect of late Narendra Ramsiari holder PPO number, so along with last payment certificate as received from the bank, as both the petitioner and his wife Fukon Ramsiari already died on 27/1/24 and 13/11/16 respectively as per death certificate. And last letter is my lord, page 42. Page 42.
Page
42. That book is also there, but I am reading the original copy. With reference to subject cited above, I write to the informed that late Narendra Ramchari ex-PSO Havildar of SB organ holder PPO number so since expired 2024 married Bharati Ramchari as second wife on 3/4/17 after the death of the first wife Srimati Fulkon Ramchari who expired on 13/11/2016. Now, after death of the retired government servant, his second wife, Srimati Bharati Ramchari, has submitted a prayer for inclusion of her name in the PPO book of her deceased husband and sanctioned the family pension in her favor. I therefore forwarding here with the following documents submitted by Bharati Ramchari's second wife of so received from the Superintendent of Police Assam, by memo number so and request you to look into the matter and take further necessary action. This letter was written by the Assistant Inspector General of Police to the Madam AG, Madam. So matter is pending before the AG.
Now what do I do?
My land has been simply.
Why have you enclosed an order of 2019? Why? I don't think this is a case for disposal like this.
No.
Here, my
No,
lord.
not-
Then you will have to file another contempt.
Yes, my lord.
You want that?
Let him take instruction, my
My
lord,
lord,
according to me.
I will definitely take instruction, but your lordship for kind perusal, page number 23, annexure 4 of the said petition, this marriage was notary marriage, notarial marriage. Whether we have a marriage,
No, they
official
already
marriage
verified.
edition, official marriage act, or they are according to their edition, any other social marriage, notary marriage, we have, lordship, we have to look into the matter.
Why on earth have you enclosed this document? Notarial marriage.
No, as a-
Ah,
Thereby,
You have
they are
the
giving chance to us to point out now.
Ah, unnecessary document.
I have annexed everything, my lord, because at Madam, sometime it may go difficult, my lord. That's why.
What?
After Madam verification, they have issued this letter. Assistant Inspector of Police, even the Gavura certificate also there, my lord. SP also written. Page 9, at 31, certificate given.
The next of kin certificate is also given.
Yes, my lord.
So they have also recognized his wife.
Yes.
No, that's all right. Well, let us kill,
Huh?
now ball is it has, let's say, let us take instruction, Miller, in this regard, we look into the matter, entire matter. Definitely, we are not against this one. If she is entitled, definitely we'll get it. But we have to verify and because this is one of the vital documents is there, the marriage. That marriage. Notarial marriage, one of the reasons When, anyhow, I'm not on date today. I'm not on, I have to take instruction and maybe fix after 2 weeks.
This treasury officer, what does he write? As per the so and so remand, his wife Pulonio died in year, the pensioner has been drawing pension here through PSBI so and so.
Fulkon Ramseri earlier wife name was there in the office report.
The treasury officer also says that pension to the second wife.
No, check.
Who is creating the problems?
No,
Mr. Das. Huh?
Easy.
Easy.
so I have to take instruction, this why it is being, generally we don't do. Anyhow, sometimes maybe give.
Generally, the easy only does, Mr. Borua.
But Lordship, one thing, off record, AG is made for this only. Otherwise, we have job. We do not have any job. We do not pay pension. We have to look into whether documents are correct or not. That is our duty, my lord. If these documents are correct and complete, say it is there, definitely will pay, my lord. Nothing goes from our pocket. Only we have to see we are made for, our section is made for that purpose.
So this marriage contract and marriage certificate is by this Assistant Inspector General of Police. Is this the notary marriage certificate? Page 42.
Yes. Marriage,
Yes, yes.
marriage contract and marriage certificate.
All accepted papers. That's why we send the letter to the zero to the. So that she can be able to get her.
Hello, I think I have to make it proper so that they will give it to you. Heard Miss issue notice making it returnable on 27th of February 2026.
Maybe prior to that or after 31st, we learn.
Huh?
Maybe prior to that or after 31st, second.
31st, there is no February.
No, this 31st January. Your lordship is fixing on February.
28th of February.
Oh, yes. I thought it's January.
No.
Because my
20
mind is-
27th of February
You're right,
2026.
Sorry.
Mr. A. Chakraborty accepts notice on behalf of respondent number 1, 3, 4, 6, and 7.
7 to
Oh, no, 6. Okay, finance, nobody. Have you seen any of these finance people anywhere loitering
I have
out there in
seen
the corridor?
Gogoi, I have seen Mr. Gogoi. B. Gogoi, I
I've
have
seen
seen
it.
him in Barn.
Mr. B. Gogoi accepts notice on appears on behalf of the respondent number 2 and respondent number 7.
I am for 5.
Mr. C. Burwa accepts notice on appears on behalf of the respondent number 5. The grievance of the petitioner herein is the non-finalization of the family pension to the petitioner. In spite of the fact, for the last more than a year, thereby causing great inconvenience to the petitioner. The materials on record reveal that the petitioner's husband one Narendra Ramsari bracket was a PSO Havildar. Full stop. During his lifetime, he married one Pulkon Ramsari. And her name was inserted as the wife of late Narendra Ramchari. During the footstool, the said Pulkon Ramsari predeceased late Narendra Ramsari, inasmuch as late Pulkon Ramsari expired on 13/11/2016, whereas late Narendra Ramchari expired on 27/1/2024. The materials on record further reveal that on 3/4/2017, the petitioner married late Narendra Ramchari, and out of their wedlock, a daughter is also born. Is it? Daughter?
Daughter possibly, my lord, first wife,
Also married?
she is already married.
Married, yeah. Justo. Justo. The materials on record, that is, the death certificate issued, the certificate issued by the Gaon Pradhan, the next of kin certificate issued, as well as the certificate issued by the Superintendent of Police, categorically show that the petitioner is the surviving wife of late Narendra Ramchari. Footstep. The materials on record further show that upon the death of late Narendra Ramchari on 27/1/2024, the authorities, more particularly the respondent number 3, 4, and 6, in whose department late Narendra Ramchari rendered service, have issued various communications to the respondent number 5 for finalization of the family pension of the petitioner. Full. A period of more than a year have passed by, but till date, the petitioner have not received the family pension. It is under such circumstances the petitioner has approached this court. List this matter. The respondent number 5 is directed to apprise this court as to why the family pension of the petitioner have not yet been finalized. Full stop. It is, however, it is further observed that pending the next date, it shall not be a bar for the respondent number 5 to take appropriate steps so that the family pension of the petitioner can be finalized from their end. More so, taking into account that the petitioner the end. Again, Miguel.
Get particular.
Huh?
Which was required to be observed by us, Lordship, that
Which one?
notarial marriage. Because we have to look into notary marriage, also we have to look into, anyhow we'll look into.
I'm not said about the notary marriage because of the fact that the other documents categorically shows that all the authorities have
Yes, yes.
categorically shown. That is why I mentioned those.
We'll find out. Highly obliged.
I would have said otherwise about I'll say about the saying about that she's old person, but seeing her age in the affidavit, then immediately I kept quiet.
We are Lordship.
For admission.
Motion says. Motion says so. Mr. Mohanto, would it be proper on the part of this court to take up this matter, taking into account that I am not holding this roster?
In fact, this was also in my mind. I wanted to point it out to them. So earlier, when it came up before other bench, not a assigned bench, then they raised objection. So, so far I am concerned, I have no choice. This is your lordship matter.
I don't
They
think it
indeed
would be
take
proper
part
on
of
my
idea.
part. Let it go to the regular bench 4 now. We'll have it on another day.
Leave it to your lordship, but I have no choice.
Because at that point of time when I was holding the
Yes.
bench, so it won't be
That
proper.
time lordship was holding that bench. Now it is bench 3, I suppose, lordship is holding. It belongs to 4.
More particularly when there is another requisition where affidavit has been filed today or yesterday.
Today,
Today. So it won't be proper today.
file it, even also.
Yes.
Succeed. They file it, I find, I'm told, instruction is, they have indicated certain law points and all. So for law point is concerned, you can take care of factual part. What is there, I'll have to go through it. And let it come up under the, immediately after vacation.
Now, you see, there are two things. If I'm not taking up the matter on the ground that I'm not holding the bench,
Yes.
then I would not say regarding filing of a reply.
Yeah, yeah.
I will only say that let it come up before the
True.
appropriate bench. I'll only fix a date as per your convenience. When should I have it on? 20?
20th,
20 is a Tuesday?
after you. 28th, yes, Tuesday. Can you?
Have it on Tuesday? In the meantime, if you want, you can file your reply.
Okay. Tuesday. When? Well, just a minute. 20th, then 22nd. Net I got to find out to the guy. 22. 22nd.
Or why don't you have it on 27th?
It would be another
27th will be better because what happens here again after a long holiday, again we are having all this 23rd is closed again, then there will be motions and all.
23rd, 24th, 25th.
Closed. 26th is also closed.
Huh?
So if-
27th is there.
27th.
Yeah.
Taking into account that this court is presently not taking up civil bench 4. Taking up the roster of civil bench 4. Let this matter be listed before the appropriate bench. Let these petitions be listed before the appropriate bench. Mr. K.K. Mohanto, the learned senior counsel, appearing on behalf of the petitioner, expresses urgency in the matter. Accordingly, list the matter on 27/1/2026. There being also an interim order. The same stands extended till the next date. I passed some interim orders there.
Apply for the.
No, that is an interim order.
There is no interim order.
That is an interim order.
There is no interim order.
Para 15, Malad.
Para 15, na?
Lordship has given them liberty.
No, that is an interim order. That arrangement will continue.
So, the interim directions which have been passed at paragraph number 15 in the order dated 17/12/2025 stands extended till the next date. First, liberty, however, is given to the petitioners to file reply to the affidavit in opposition filed in WPC number 7263/2025 on or before the next date.
For motion item 38,
Where is Mr. Purkashta? With one of the biggest petitions he has filed. 92 pages. What is the case actually?
Worship, the case is regarding the regularization of the service and consideration for the casual service without any remuneration.
Huh? Let us see the relief what he is asking for. You are FCI?
Yes, Lordship. I'm appearing on behalf of Mr. B.K. Singh. I'm appearing on behalf of Mr. B.K. Singh.
None appears on behalf of the petitioner when the matter is called. Accordingly, list this matter for motion again on 27th of January 2026.
item 40,
Petitioner has been declared unfit in a medical manner and will say page 49. Page 49 minutes. Two B, my lord. Unfit due to anemia corporis post-inflammatory hyperpigmentation and plus anemia. What happened, my lord? The review medical board sent the petitioner to the my lord, future medical college for open examination and opinion of dermatologist, my lord. And dermatologist, my lord, after examination, given opinion that petitioner is fit for job, my lord. Dermatologist, my lord, expert, my lord, given opinion that petitioner is fit for, my lord, job, my lord. That was not considered, my lord.
Where is the report of the
Report supplied to me, your petitioner took a photocopy, my lord, which I cannot annex, my lord. Let them produce, my lord. They have sent me, my lord. They have sent me, my lord. The review medical board, my lord. The last line, my lord, is recommended, my lord. Here only says, my skin is opinion taken from SMC's SLR report attached. But not deals with the my lord, opinion, my lord. And in the my lord, review medical board, there is no expert of my lord, skin specialist.
issue notice. When did I have the other one where Mr. Count I have noticed?
Yesterday, item number 10.
Huh?
Yesterday, item number 10.
What is the next date?
Next date, March. In March.
Kausun, Kali item number 10 on.
In March.
16 March.
16th March.
16th March. Issue notice making it returnable on 16th of March 2025. Mr. S.S. Roy accepts notice on behalf of all the respondents. The petitioner herein, extra copies of the writ petition be furnished upon him by tomorrow. The petitioner herein is aggrieved by the rejection of the petitioner's candidature on the basis of the opinion dated 1/12/2025 given by the Review Medical Examination Board of the respondents, thereby opining that the petitioner is unfit due to tinea corporis post-inflammatory hyperpigmentation plus NEVI, NEVI. The learned counsel appearing on behalf of the petitioner drew the attention of this court to the very impugned opinion and submitted that the said opinion has been rendered by the Review Medical Board on the basis of an opinion given by the skin specialist from the Silchar Medical College Hospital. The learned counsel submitted that the petitioner could procure a copy of the said opinion, wherein the assistant professor had categorically opined that the petitioner was fit and the skin infection was not contagious. Full stop. The learned counsel further referring to the guidelines for recruitment, medical examination in the Central Armed Police Forces and Assam Rifles as revised in the May 2015 further submitted that the disease, that the reason, that the disease for which the petitioner have been rejected do not fall within the ambit of clause 6 of the said guidelines. Stop. Taking into account the above, now further to that, the learned counsel also referred to the revised uniform guidelines for review medical examination dated 31/5/2021 and submitted that the guidelines by which the Review Medical Board had rendered the impugned opinion is contrary to clause 6D of the clause 6D. First, this court have also perused the materials and record and is of the opinion that the petitioner have been able to make out a prima facie case for issuance of interim directions pending the next date. Full stop. This court accordingly directs the respondent authorities not to fill up one post in in the rank of the constable GD
In Central Armed Police.
in the Central Armed Police Forces on the basis of the notice dated 5/9/2024 till the next date. The respondents herein are directed to bring on record their stand by filing the affidavits on or before 6th of March 2026. Liberty given to the petitioner to file reply on or before 13th of March 2026. In time, full stop. An attempt shall be made to dispose of the petition on the next date.
6D, 6D, review medical board guideline 6D.
6D.
D, not lordship it said B.
No, I said D. D only.
Okay.
42.
Yes, Mr. Apprentice. What happened? Did you find anything?
No, there is no directly, but there is a judgment of our order of our High Court also, where the refinery has admitted that the principles laid down by the Supreme Court judgment is applicable on them.
Show me that.
So I not procured a certified copy because of time. Completed.
These were the time when the courts were very benevolent. unlike me.
Otherwise also, Lordship, otherwise, if they are not incorporating the apprentice benefits or apprenticeship, the very object aim of the apprenticeship act is frustrated, Lordship. Because
Are you still carrying out the jobs as apprentice?
yes, Lordship, these are boiler operators, boiler attendant, these are basically on the, because the qualification is also apprenticeship is there, Lordship. And under the Lordship,
Apprentice section, how?
he is a holder of boiler attendant national certificate, Lordship. These certificates are used to issue under by the Director General of Training, Ministry of Skill Development.
Let's see the apprenticeship acts.
The aim, object, and Lordship, along with rules, Lordship, under the apprenticeship has been described in Supreme Court judgment from paragraph 3 to 6, Lordship.
Okay, now let us see your contract of apprenticeship.
It is a page, Lordship. Page 42, next to the
Page
42, Lordship. Annexure G. This is the engagement letter. And 45 is the model contract which I have to sign and upload in the system. Because during that period, I was treated as workman.
You can't be treated as workman. That's the bar as per the act itself.
Lordship, there is a railway, which is referred. Certified standing order are there of the refinery.
You can see section 18. Apprentices are trainees and not workers. Undergoing apprenticeship training in a designated trade in an SL shall be a trainee and not a. The provisions of any law with respect to labor shall not apply or in relation to such apprentice.
The standing order is not.
Standing order can't go against the law. You kindly try to come yourself within the ambit of 22. That is what I'm trying to find out, whether you will come within the ambit of 22. Where's the act? I gave you time yesterday also.
So I tried to.
You have not looked into, or is it for me to help you out?
Lordship, I have gone through, so it is soft copy, Lordship.
Soft copy. Okay, go through the soft copy. Only come to page 42. You are an apprentice and not a worker. You shall be covered under the certified standing order applicable to workmen of year and shall be placed under the administrative authorities prescribed. Offer of the new is subject to so and so. There is no contract of apprenticeship with the substance. Number 13. Paragraph for page 44. This para 13, clause 13
Yes,
goes very much against what is your case you made out.
yes. This court judgment also, this was discussed, Lordship. But considering the object, because state has invested time and money for training of these apprenticeships. Skilled worker is also required. These are skilled human resource, and if the period of their service has not been utilized after apprenticeship, this is a wastage. That is the view taken. And that is why allowed that the period of apprenticeship which they have engaged, proportionate period be relaxed,
You are trying to apply for what?
apply for, Lordship. It is
Which post?
given to faith,
Huh?
post this, Lordship,
What? Where is the advertisement?
advertisement is a page, Lordship.
52. These are all junior engineering assistant.
Yes, Lordship.
What are these posts?
My post is at serial number postcode 202, junior engineering assistant grade 4 products PU.
How many petitioners are here?
Only one. In fact, for the general category, only there are 2 posts. Unrejected.
Did you submit any representation to them? Directly here.
On 20th, Lordship, December, advertise was published, Lordship.
So then why didn't you approach them? What is the last date?
Tomorrow, Lordship.
Where do I find it?
That.
Hmm. Where?
Lordship, we find at page 64.
Page
64.
64.
Under P1.
Now, tell me one thing, whether they would accept if you are overaged in the online portal,
No,
then how to do?
as it can, I may be allowed to submit offline application.
So
In the
that
meantime,
means
they will-
everything I violate means I have to interfere with many aspects in an advertisement. How to apply also. Candidates are required to complete the online application along with payment of non-refundable application fees and so and so. Because you have to first register yourself by creating a profile creation. And when you apply for a profile creation, your age goes up.
Normally, but in medical admission and other cases, Lordship, the courts generally directed to submit offline application and thereafter the authority to decide. So there is relaxation is concerned.
And they don't have a standing counsel. That is the another big problem. Na? If they were present, I could have passed some order.
Nowadays, panel advocates are there, like insurance case, after receiving the notice, they have assigned the.
This is IOCL or what is that?
This Guwahati Refinery, Guwahati Refinery,
Oil.
Indian Oil Corporation.
Indian Oil Corporation, IOCL. Mr. P. Bhardwaj. Huh?
Notice has to go in service matter.
Understood, but the fact remains that there is an urgency in the matter.
I vaguely
I can't
remember-
allow him to participate also. There is a big problem.
Yes, because they don't allow us to represent refinery. IOC marketing division doesn't allow us to represent refinery. Refinery usually engages a counsel after receipt of notice.
Right, thank you.
And earlier, I vaguely remember there was another apprentice matter.
Huh?
Many years ago, we did appear in a apprentice matter. But what the result, I don't remember.
No, that's okay. There's no quarrel with that. I'm not asking you to take service, but give me a solution.
Now, if I
You
may,
see,
they
normally apprentice, there is no such right. Although section 22 gives something, every employer shall formulate its own policy for recruiting any apprentice who has completed the period of apprentice training in his establishment. You have not completed.
I've completed. Lordship.
When?
Even on June 2025, I annexed the national apprenticeship.
June 2025.
Yes.
Then what right do you have?
No, being as a apprentice, Lordship, I have
Anything
qualified.
in
I have
subsection
get-
1
I
where
have
there
get
is a
the training,
condition in the contract that the apprentice shall, after completion of he has served the employer shall on such complaint be bound to offer such suitable.
Yes,
Provided
now
that where
difficult-
such period of remuneration is not in the opinion of the apprentice reasonable, he may advise such demand. Huh?
After 23, 25, I am from 23, 25 batch, Lordship. completion of examination, this is the first advertisement.
The judgment which you are relying is, I think, much water must have flown thereafter. AIR 2013 SC 403 goes against you. Because if your terms of the contract stated something, it would have been different. I can't help you.
On the basis of the contract, Lordship, I have given the qualifications which are requisite for the post. And it is not that, Open University or something else, it is under their institute, Lordship, and getting some Lordship, stagnant Lordship. I was able to be disciplinary proceeding, everything is applicable on me. My name is in the role of the apprentice under the refinery Lordship. And Act says basically two things. One is for demand of skill labor, Lordship, and other is for employment opportunity. And that is why the 1995 Supreme Court judgment, Lordship, the four conditions they have.
No, the age relaxation to give, it's a very difficult thing. I can do at best one thing. Let me not interfere with this advertisement and observe what has been stated in the Supreme Court. And you can submit your representation, they may consider. That's the best I can give. But I can't allow this. I'm going to reject your prayer for allowing you on the basis of this in being an apprentice. That I'm going to reject.
Yes.
Because if I don't reject it, becomes otherwise.
Yes.
You are at liberty. Huh? That's the only way out.
That is.
Because you see, he has come at the nick of the time. Without the IOCL being a party out here, without hearing them, I can't allow pass any further orders.
So they are based at Dumbati.
Huh?
They are based at Dumbati. So tomorrow he can take a chance if he can, but I don't think Dusty Service will be prepared that fast by the registry.
No, that I can get it done through them only. I can very well pass an order that a copy of these things shall be served upon so and so.
I
in the
think they
post.
can engage the council. Usually they engage Mr. Senior Counsel K.N. Choudhury. I've seen many recruitment money.
What do you want? Try your luck again tomorrow, or should I pass that order?
First option, Lord. First option.
Huh?
First option. First option.
First?
Option, Lordship, and what stated there, referring to the matter to them.
To consider. They may consider this aspect.
Yes, Lord. I will
Because there cannot be an offer of employment, nothing. Because the judgment which you are relying is very difficult to hear. Chalo, let's see how. Oh yeah. Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Full stop. The petitioner herein has approached this court seeking appropriate directions upon the respondents thereby to provide benefits to apprentices under the Apprenticeship Act 1961. And more particularly, taking into account the observations of the Supreme Court in the case of UP State Road Transport Corporation and another versus UP Paribahan Nigam Sisukha Berozgar Sangha and others reported in AIR 1995 SC 1115. And further, the petitioner have also sought for a direction upon the respondents to grant age relaxation to the petitioner by excluding the period of apprenticeship training from the age computation and to permit the petitioner to apply and participate in the recruitment process for the post of
Junior engineering assistant.
Engineering Assistant, grade 4.
Within bracket PNU. PNU.
PNU. Full stop. The brief facts of the instant case, as it appears from the materials on record, is that the petitioner herein, pursuant to a notification for engagement of apprenticeship dated 24/9/2022, was engaged as trade/technician apprenticeship at IOCL Guwahati Refinery. For a period of
24 months.
24 months with effect from 1/2/2023 to 31/1/2025. Full stop. Pursuant to the petitioner completing the said period, completing his engagement as apprentice in the designated trade boiler attendant, a certificate was also issued by the Directorate General Training of the Ministry of Skill Development and Entrepreneurship on 11/6/2025. Full stop. In the process of carrying out his work, full stop, the petitioner had also crossed the age of, what is the age?
26 years.
26 years. Full stop. In the meantime, no, cross the age. Full stop. On 2012/2025, the respondent corporation issued an advertisement calling from eligible candidates for filling up of various posts. Full stop. Amongst the various posts, the petitioner herein is interested in applying to the post of Junior Engineering Assistant dash Roman 4 bracket P and U. The last date for submission of the age page 52 is the advertisement?
Yes.
Huh?
Yes.
Are you sure?
Yes.
Okay. Now, what is this? Kindly come to page 55. Candidates in possession of National Apprenticeship Certificate, which you have.
Yeah.
In boiler attendant under the Apprentice Act 19 must upload NOC with so and so. However, in case of not having endorsement of equivalence of second Iman for which they apply, a candidate may be provisionally allowed in selection of so and so. Now, where's the age?
Page 50,
Huh?
59, Lord Sir.
Good stuff.
The heading E. Meaning
Clause E of the said advertisement stipulated the minimum and maximum age limit. In terms with clause E1, the minimum age limit is 18 years and the maximum age limit would be 26 years for unreserved candidate as on 31/12/2025. It is the case of the petitioner that the petitioner during that taking into account the scope and ambit of the Apprenticeship Act 1961 and the judgment of the Supreme Court in the case of Uttar Pradesh State Road Transport Corporation, SUPRA, the respondent authorities ought to have also granted certain relaxations in respect to those candidates who have completed training under training and more so when under the Apprenticeship Act 1961. The same having not done, the petitioner has approached this court by filing the present writ petition. Mr. U. Dutta, the learned counsel appearing on behalf of the petitioner, drew the attention of this court to the judgment of the Supreme Court in the case of Uttar Pradesh State Road Transport Corporation and another SUPRA, and submitted that the Supreme Court dealt with the object behind the Apprenticeship Act 1961 and the rules framed therein under, and further observed that certain relaxations are required to be given in spite of the mandate of Section 22 of the Apprenticeship Act 1961. In that regard, he referred to paragraph 3, 6, and 7 . 7, na? Anything else?
12.
And 12 of the sage judgment. Full stop. This court have heard the learned counsel appearing on behalf of the parties. And perused the materials on record, including the advertisement dated 2012-2025. From the materials on record, it is seen that the respondent corporation had engaged the petitioner as an apprentice for a period of 24 months with effect from 1/2/2023 to 31/2025. In the engagement letter dated 19/1/2023, it is categorically mentioned at clause number 13 that a respondent corporation shall have no obligation to offer employment to the petitioner, and the petitioner also cannot claim right for employment on the ground of completion of apprenticeships. This court have also perused Section 22 of the Apprenticeship Act 1961, which mandates that the employer would only be bound to offer employment to the apprentice if the contract of apprenticeship contains such clause. Full stop. This aspect is further affirmed by the Supreme Court in the case of Haryana Power Generation Corporation versus Harkesh Chand, reported in AIR 2013 SC 403. This court have also perused the advertisement wherein though for the purpose of eligibility for the post of junior engineering assistant dash Roman 4 bracket P and U, it is mentioned that certificate that the candidate should also possess boiler competency certificate with second class OR. Certificate with second class or National Apprenticeship Certificate in the boiler attendant under the Apprenticeship Act 1961. But while mentioning the age relaxation at clause E, there is no benefit being provided to any apprentice who were engaged by the respondent corporation earlier. Taking into account the above, it is the opinion of this court that in exercise of the powers of judicial review, it would not be proper on the part of this court to interfere with the advertisement, thereby permitting the petitioner herein to participate in the said recruitment process, taking into account that the petitioner have already crossed the age of 26 as on 31/12/2025. Next. The non-exercise of the jurisdiction by this court to permit the petitioner to participate is, however, different from the fact that the respondent corporation would not, however, preclude the respondent corporation, who are the authors of the advertisement, to permit the petitioner to participate. More particularly, if the respondent corporation duly considers the observations of the Supreme Court in the paragraphs which, in the case of Uttar Pradesh State Road Transport Corporation and another, Supra. Taking into account the object it is the opinion of this court that the observations of the Supreme Court in the said judgment is required to be reproduced. Accordingly, this court therefore reproduces the following paragraphs of the judgment in the case of so-and-so, which are the paragraph 3, na?
Yes.
3,
3, 4, 5, 6, 7.
4, 5, 6, 7,
11 and
11,
Yeah.
and 12. Full stop. It is the opinion of this court that a liberty should be given to the petitioner to submit a representation highlighting the aforementioned highlighting the observations of the Supreme Court in the case of so and so, and more particularly to the paragraphs above quoted. It shall be absolutely within the jurisdiction of the Indian Oil Corporation, of the respondent corporation, to consider the same, taking into account the object behind the Apprenticeship Act 1961. With the above, the instant petition stands disposed. I can't do more than that. Huh? I hope it may help you out.
He qualified the PST, PAT, everything, then there is a detailed medical examination. Wherein he was found to be unfit for 2 reasons at page 55A yellow. 55 yellow is the initial detailed medical. Left shoulder, lower than right. The second is left shoulder, middle asymmetry. So against this, he has preferred a review before the review medical board. Now, when he appeared before the review medical board, your lordship, he was directed to visit the orthopedics department of Silchar Medical College and Hospital. When he appeared before the review medical board, your lordship, the review medical board did not examine but referred him to the orthopedics department of Silchar Medical College at page 56A.
Page
56A. So this is a referral by the review medical board to the orthopedics department that so unfit by DMA due to these 2 reasons, investigation's opinion required to rule out left shoulder lower than right and left shoulder asymmetry. So now orthopedic department at page 57 asked him to undergo a X-ray, your lordship. X-ray of true nature, FP and auxiliary in 2 ways. And then your lordship could find at page 58, the radiologist gave his opinion on the X-ray that bony outlines and density appear normal, visualized joint spaces appear normal, top spaces appear normal. Thereafter, on the basis of this report, your lordship, next page, the Register of Orthopedics gave an opinion wherein he says X-ray WNL means within normal limit, your lordship. Then RNM means range of motion found to be normal. An impression is given that right scapula at a higher level, but muscle power is 5 out of 5. So he has given opinion that muscle power is okay, range of motion is also okay, X-ray is within normal, but their impression is that right scapula at a higher level. Now, on the strength of this, your lordship, the RME has rejected his case at page 61, but 60 I have given the typed copy. Now, they have said that he is unfit due to right scapula higher level than the left scapula, and within bracket they have said it is a case of drooping of left shoulder present. This is the case, your lordship. They're on the ground of drooping of left shoulder. Now, lordship, as per this advertisement, the detailed medical examination has to be done as per the uniform guidelines. Now, I'll take your lordship to the uniform guidelines, which are at page number 62 it starts. And then lordship will kindly see page number 67. Just one of the aims, your lordship, at paragraph number at E, quantity, capable of performing duties without aggravation of existing physical defects or medical conditions. This is one of the aims. And then general instruction, lordship will say kindly A of general instructions on the same page at page 67. That the recruiting medical officer while conducting medical examination. Page 67. 2 general instructions I will show you lordship. The recruiting medical officer while conducting the medical examination of a candidate, if finding the candidate to be unfit, would record the parameter with reference whereto the unfit has been opined. A reference would be made to the requisite standards prescribed or known to be prescribed
and accepted as such by the experts in the field. This particular instruction should be strictly adhered to. This particular instruction should be strictly adhered to, that if they find him to be unfit, they have to say that this is the standard and because of this, you are not fit. And some examples are also given, Your Lordship. Secondly, another important, Your Lordship, an instruction at page number 69, I'll just show you, Your Lordship, and then page 69. Point number H, Your Lordship. Page 69. Lordship has got it. Human body may contain so many defects, deformities, that it is not possible to list all causes of unfitness in the medical recruitment instructions that may militate against efficient discharge of service. Neither is it possible to list all trifling cases where the candidate may be accepted or rejected. Therefore, the recruiting medical officer needs to use his clinical acumen to the best of his knowledge and keeping in view the best interest of the forces. If the cause of rejection is not mentioned in these instructions, it has to be correlated to an infirmity with reference to either non-medical literature on the subject or a parameter set out. In case of unfitness, where known references are available, the defect or infirmity may be elaborately justified with reference to service requirement for which the candidate is being rejected. Now, Your Lordship, my case, they have founded that right scapula at a higher level. Now, at page number 72, Your Lordship, the another grounds for rejections are given. There are total 29 grounds. I am not falling in any of these categories. Now at page 73, the minor acceptable defects are given, Your Lordship. Now here at point number M, only because of tilting of pelvis or drooping of shoulder, which they have found out in my case, may not be rejected unless it is associated with some specific disease or disability. If they find out that my case is a case of drooping of shoulder, Your Lordship.
18, 16, na? 16. Issue notice making it returnable on 16/3/2025. 26. Mr. So-and-so accepts notice on behalf of respondent numbers 1 to 6. Extra copies be served upon him by tomorrow. Gustav. Petitioner herein is aggrieved by the rejection of his candidature on the basis of the opinion of the Review Medical Board dated 22/11/2025, wherein it was opined that the petitioner was unfit due to right scapula higher level than left scapula, bracket, dropping of left shoulder present, bracket closed. Gustav. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, have drawn the reference, have drawn attention of this court to the very opinion, impugned opinion, and submitted that the said opinion was based upon the orthosurgeon opinion taken from Silchar Medical College Hospital, Gustav. In the said opinion rendered by the Silchar Medical College Hospital, there was no such it was declared that it was opined that the bony outline and density appeared normal and visualized joint spaces also appeared normal. It was also opined that the soft tissue shadow appeared also normal. The learned counsel appearing on behalf of the petitioner further drew the attention to the general instructions for the recruitment board contained in the Uniform Guidelines for Medical Examination Test for Recruitment in CAPFS, NG, NSG, and AR, and submitted that it is the requirement of the guidelines that when there is any defects oblique deformities which is either known medical literature which with reference to defect or deformity, comma, where no known references are available, the defect oblique infirmity may be elaborately justified with reference to service requirement for which the candidate is being rejected. The learned counsel further submitted that the respondent the impugned opinion also do not state is contrary to the opinion obtained from the orthopedic surgeon of the Silchar Medical College and Hospital. Additionally, the learned counsel, referring to clause 6 of the guidelines, submitted that the said clause 6 stipulates the general grounds for rejection, and the general grounds of rejection does not contain the dropping off a soldier, dropping off the soldier. Rather, it is a minor acceptable defect as mentioned in clause 7N of the guidelines. He therefore submitted that the impugned opinion, medical opinion, is required to be interfered with. To stop. This court have perused the materials and record and have also taken note of the opinion rendered by the orthopedic surgeon of the Silchar Medical College and Hospital and the guidelines which have been issued, and this court is prima facie satisfied that the petitioner has been able to make out a case for passing interim directions. Accordingly, till the next dates, comma, one post of Constable GD in the Central Armed Police Force, in terms with the notice dated 5/9/2024, should not filled up till the next date. The respondents herein are directed to file their response on or before 6th of March 2026. Liberty given to the petitioner to file reply by 13th of March 2026. An attempt shall be made to dispose of the writ petition on the next date. Mr. Roy, your 5/9/2024 has led to litigations after litigations. What is to be done?
23 litigation is still pending.
See, what is to be done?
All medical.
Yes.
One of the petitioners assailed the election procedure and the appointment of the promotion and appointment of the resident number 5, the post of process server in NSCT establishment Noga. Now, before taking your lordship to the impugned selection procedure, what I want to show your lordship is the last recruitment process by which the petitioner and the private respondents were selected. That is that the results. It started in 2011 and 11 and 13. The advertisements were published, separate advertisements for separate posts, and the specific criteria was given that the applicants can apply for only one post that is there in the advertisement. The results were published, separate merit list for office peon and peon for officer. These two posts we are concerned with. And in that particular merit list, the respondent number 5 secures 99 odd numbers. I secure 93 marks. And in 2024, they prepared a gradation list memo, although objections were not called for. Now, in the gradation list, I want to show your lordship at Annexure 10, page 36.
Let us come, Mr. Yar, to the advertisement. Let us not
The
go
early
into
advertisement.
bed.
Early advertisement.
No, now, what has happened?
Recent advertisement and the selection procedure records, those are.
Let us first see the advertisement. It is Annexure 13, page 42, isn't it?
No, my lord.
What no?
But this is the subsequent advertisement which has been floated to fill up this particular post which fell vacant after the private respondent was promoted to the post of processor.
Okay. Now, who are you?
I am the third
The
candidate.
gradation list of the year 2025. What is your name?
Not, in 25, my name is Jitu Bora.
Huh?
Jitu Bora at page 41. This is after the promotion exercise. ma'am.
You are a peon.
I am a peon for officer.
Then,
The office peon fell vacant because the process server, the
okay. Now tell me, this is Jitu Bora. You are Jitu Bora. Okay, so you are working.
I'm working.
Now, what has happened?
What is-
And who is the respond number 5?
Let me take your lordship to the earlier gradation list. Stop.
No. Tell me who is the respond number 5?
Respond 5 was the office peon. I am the peon for officer.
Where is his name?
My lord, his
What is the name of the respond number 5?
My lord,
Not prepared. We have it after vacation.
Then
Then move fast.
Page 40, ma'am.
There are a lot of councils waiting.
Page 40. First.
What is the name of the respond number 5?
Opera.
You don't know. Where is he? In the gradation list?
At page 40. Now he's a process server.
Hiranna Bollabura. He's a process server.
Yeah.
Then,
He has been given the promotion
okay, this is after promotion.
after promotion.
Okay.
And if I may take your lordship to the.
Now you are challenging his promotion.
His,
Okay, let us see then prior to that.
the impugn order, that page.
Where is the
37.
advertisement?
Those, I am not armed with those papers, man. The selection procedure records and the advertisement, I am not armed with them.
What is this page 21, 22?
But that is the earlier recruitment process by which we were appointed in office peon and peon for officer.
Okay, then
But what has happened if I may take your lordship the impugn order at page 37, you know? Page 37,
Hiranna
Bollab Bora,
and your name is
Jitu Bora.
Jitu Bora. Where is your
Impugn order is at page 37.
post of office peon Hiranna Bollabura? And yours is for peon for officer Jitu Bora. Then
Thereafter.
you are appointed on the same date.
Yeah, no, my lord. I was appointed on 7th of June 2013.
Where is your
Page-
appointment order?
My lord, that page,
7th of June, election 9, page 33.
yes.
Then,
Thereafter, the gradation list which they prepared. At
Okay.
page 36, everything is reflected, madam.
34.
34 it starts, 36, everyone's name is guided. 36, Jitu Bora is senior, 7/6/2013, and your lordship will mark the qualification.
Date
High
of
secondary.
initial appointment. 7/6, yeah. Okay, then,
And Hiranna Bolla Bora, serial number 4, 11/6/2013, and your lordship will mark the qualification, class 9 pass.
then,
Thereafter, the impugn selection procedure is followed, carried out. And what my employer does internally is he prepares another gradation list, which is not published. He prepares a gradation list and marks the seniority based on the marks they obtained in the merit, in the selection procedure, which was carried out in the year 2013.
rightly.
But separate recruitment process, madam, not joint recruitment process.
Okay.
So they prepare the seniority list based on the marks they obtain, and based on seniority come merit. This person is given the promotion at page 37. This is the impugn order.
So there must be an advertisement?
That I don't have that, madam. I don't
Okay.
have that.
So in pursuance to that selection test and Divya will say, as well as the recommendation of the selection board meeting held on Iman, Hiranna Bolla peon is hereby selected to the post of AR. This happened on 4th of December.
4th of December.
Now what is your problem?
Now on 19th, they floated a new advertisement so that feeder post is going to be filled up very soon. Now what has happened clearly, your Lordship has seen I'm senior to Hiranya Ballabh Barua, and they carried out, they made another gradation list internally by taking the marks in the merit examination. So that cannot be done. One point is that. Second, the draft rule says, draft rules is to be followed in such promotion exercise. It says that the minimum qualification for promotion is HSLC pass, and he is clearly class 9. Those are my two grounds, my lord, for challenge. And I may take your lordship to one.
Let us see the draft rules.
Draft rules. It's the relevant portion is at page 76, my lord. 19 process server.
Where?
Page 76. Process server. For promotion must be HSLC pass and 5 years of experience. I'm not government.
This must be some mistake somewhere.
It has been changed.
No. There's a mistake
Latest
somewhere.
one is here.
No, there seems to be some mistake.
Yes, sir.
Yes, there's a mistake. I know that there's a mistake out there.
Like I'm with a judgment which your lordship has passed in
This is
versus state of Assam. There your lordship has observed.
No, it is only in direct recruitment, it is HSLC.
It changed full.
For promotion, there is no HSLC. Therefore, I am saying so.
It has been changed. Now the first ground remains, my lord, that clearly I am senior to the private respondent, both the private respondents. I am actually marked at point number 3. I am given the position of third in the entire selection process at the promotion exercise. So since I'm not.
What is the urgency?
My lord, if they fill up that particular post from which this private respondent was promoted from, so provided tomorrow my case is allowed, will he have a post to go back to?
So how does it matter? Why you are thinking about him? You should think about yourself. Then how is it
At
so
this stage,
urgent?
my lord, since I'm not armed with the selection process procedure records, if my learned friend may kindly come up with the instructions as to how it was carried out. Because the seniority, how it was determined, that is all.
Okay, we'll just issue notice, nothing.
But then that particular promotion exercise may be subject to also.
Which one?
The respond number 5's promotion.
No, that is always there. Don't worry about that. That has only happened on 4 year. The subsequent advertisement shall be subject to outcome of the recruitation.
Lordship can pass that order, but there is no prima facie case in the writ petition, subject to correction. 2 advertisements were issued, 1 selection held, marks were given. Respondent number, private respondent 5, these scored 99 marks and the petitioner scored less marks. 2024 seniority list was published. Perhaps there was wrong. There was wrong. That's why my friend also said there was another list which he is not in possession. That's 2024 seniority list was corrected because it has to be based on merit. And 2025 seniority list in the top make mention about your
There is
lordship's
no
judgment.
cadre, Mr. Bharadwaj. I don't think there is a cadre that for office peon and for other of peon attached with an officer is a separate cadre.
No.
It
All
all
grade 4.
comes under the peon category only.
If your lordship would kindly see one reply from the Guwahati High Court. One reply.
Where?
My lord, at page 79. RTI reply.
The High Court, you never know what they reply.
And they refer to their own notification, man, at page 79.
This position has been settled by your lordships.
My lord, at point
Where?
number 2. Point number 2, second paragraph. Between 2 employees, X and Y, if X joined the service on 25/7/2017 and Y joined on 26/7/2017, their seniority shall be decided on the basis of their position in the merit list. If they were recruited through the common recruitment process in the light of point 2 of the notification dated 14/10/2020, irrespective of their date of joining. However, if they were recruited through separate recruitment process, then Y cannot be placed above X in the gradation list as per point 1 of the notification of 14 October 2020. But by this, they cannot club the entire selection process. Then
So
that was
your
separate- those are
advertisement
separate
was
fields.
issued when?
My lord?
When was your advertisement issued?
Yes, but it's there.
Anyway.
Page 19 in 2013, my advertisement was issued. And this particular recruitment process was taken along with another advertisement which was published in 2011, in which the private respondent participated. These two recruitment process were carried out together, and as a result, separate merit lists were prepared for all posts. The minutes itself says. So how can now they club their all of those particular merits into one seniority? That is my case. And the 14/10/2020, that particular notification also verifies.
Anyway, notice only. Nothing more than that.
On what fell from your lordship, that advertisement may be, that new advertisement may be made subject to auto on this case.
That is there. When notice has been issued, everything is subject to outcome. Issue notice, making it returnable on March 12th, 2026. Steps be taken. Mr. H.K. Das accepts notice on behalf of respondent numbers 1, 2, 3, and 4. Extra copies of the writ petition be provided to him by tomorrow. As regards the respondent number 5 and 6, steps be taken by way of speed post by tomorrow. Additionally, the petitioner is also directed to effect service upon the respondent number 5 and 6 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the promotion of the respondent numbers 5, na?
5 and 6.
Both have been
Oh, no, I
promoted.
said, no, five.
Promotion of the respondent number 5 to the post of process server on the ground that the petitioner herein is senior to that of the both the respondent number 5 and 6. The petitioner further submits that the counsel for the petitioner further submits that the gradation list has which have been prepared also, and on the basis of which the impugned selection was held, thereby promoting the respondent number 5 to the post of process server, is also required to be interfered with. The learned counsel appearing on behalf of the petitioner further submitted that in the meantime, as the respondent number 5 have also been promoted to the post of process server, the resultant vacancy has also been advertised by an advertisement dated
19/12/25.
19/12/2025. And it is the further submission of the petitioner that in the circumstance the feeder post, the said post is filled up, it would cause unnecessary, it would lead to multiplicity of litigations if the promotion of the respondent number 5 is interfered with by this court. It is the opinion of this court that the dispute in the instant proceedings requires an early resolution. Accordingly, this court directs the respondent authorities, more particularly the respondent numbers 1 to 4, to file their affidavits on or before 5th of March 2026. Liberty given to the petitioner to file reply on or before the next date. Similarly, the respondent number 5 and 6, upon whom dusty service has been directed to be effected, is also required to file their reply on or before 5/3/2026. The petitioner shall also effect the dusty service upon the respondent number 5 and 6 on or before 5th of February 2026. Full stop. It is further observed that the promotion of the respondent number 5 as well as the consequent filling up of the post by way of the advertisement dated 19/12/2025 shall be subject to the outcome of the petition. Much obliged.
It is a question.
What is this?
Petition, my lord, I am challenging the appointment of the respondent number 7, my lord, as Gaon Pradhan of charge number 12.
Gaon Pradhan of Charge 12 of so and so. Why are you challenging it?
Basically, on two grounds, my lord, I am challenging his appointment. Number one, my lord, he, at the time of selection,
What is this? Prayer number 1 is 5/1/2026.
my lord,
What is prayer number 2? Is allowing the respondent number 7 to take over charge.
my lord,
And what is this? Some review petition file?
review has been filed, my lord, it is pending. Petitioner will to direct the petitioner, my lord, to file review petition. In the meantime, my lord, you have to stay till filing of the review petition. Review petition, my lord, they are not taking up the review petition, the authority. And in the meantime, my lord, they have appointed the respondent number 7, my lord.
Okay, let us see. Where is the court's order?
My lord. Court's order was still filed.
Heard Mr. I.S. Soikia Council before it challenging the order
91.
dated so and so. According to the petitioner, the private respondent which was selected for so and so did not have the required evidence for the Okay. Did you ask for review before the review authority any interim orders?
My lord, they have filed a review petition, my lord, on my lord 25, was still find a review petition at page 95, my lord. They have received it, my lord, on 25/11/25.
Hmm.
Down below, my lord, page 25, 95, my lord.
Where is the interim order?
But in the review petition, my lord, they have not passed any order till date, my lord. Till date, they have not passed any order, my lord. So we
Now,
have
by
not-
staying suspending the operation of the impugned speaking order dated so and so passed by the director so and so
Yes, my lord.
and by restraining the year. Now, what has happened in the meantime?
In the meantime, my lord, the review authority, my lord, they are not taking up the review petition. And on 5th of this month, my lord, they have appointed the private respondent as town president. Without taking up the review petition, my lord.
So, Mr. Hawk, what should we do?
My lord, mere pendency of review, my lord. Mere pendency of the review petition is not bar for appointing the selected candidate, my lord. Here, my lord, the selection was made in 2000. Lordship kindly see his first initial order by which his claim, my lord, inserts, my lord, page 22. Page 22.
So
my
you are out.
My lord.
You are out.
He is not in charge, my lord. He is misleading the honorable court, my lord, all along, my lord.
Yes.
Page 22, Lordship, kindly see, my lord. He was engaged, my lord, as assistant of inserts.
Page 24, my
Page 22.
Page 24, there is clear order from the authority itself that I was done, sir. Page 24.
Now selection was made in 2003. He challenged my
2000?
2023, my lord. Then he approached this honorable court challenging my selection. Then, my lord, this honorable court, my lord, granted him liberty to file appeal. Writ petition was withdrawn. Then appeal filed, my lord. Appeal was dismissed.
Where is the Commissioner and Secretary, Revenue and Disaster Management Department Council?
He can pursue his review, my lord. This honorable court granted him liberty also to.
When did you file it? Review?
125th month. Within the 1 week, month. On 25th of November, we filed a review petition.
In
We,
case
I
94,
think
my lord.
Mr. Saikia will have it tomorrow. And I am of the opinion that because you see the problem this court has, earlier court did not interfere, ask you to go for a review. So instead of that, the best order would be that directing the Commissioner and Secretary Disaster Management Department to decide this within a period of 1 month.
In the meantime, my lord.
In the meantime, forget about that. If the possession has been gone, I can't revert it back.
I have not handed over the charge, my lord. I have
So
not-
within 1 month, let him decide.
I have not handed over the charge, my lord, but they have given him the unilateral charge, my lord.
You on yourself, you say that the circle officer handed over on 6/1/2026.
The order-
That's your prayer.
Assuming charge, they have passed an order, my lord, because
And on 7/1, he has taken over. That is your third relief. Isn't it? Your third relief.
on 6/1.
6/1 circle officer gave, 7/1 he is being discharging today, 8/1 today. Yesterday he has taken over. So you are not there. So let us finish it on 9/1 and directing them to complete it within 1 month. I think that is the best way out.
Only one aspect, my lord, was not really considered.
You see, the only thing is I need one thing. If it comes, otherwise I would have passed that order. But the problem arises that you filed a review in pursuance to a direction passed by this court. Now the review authority has not done so. Now how do I take over the appointment or challenge this appointment and all? You are challenging the selection, na?
They are not taking up the review petition. We approach the review authority, my lord, time and again, my lord, they are not passing any order.
So therefore, the only way I can help you is passing an order directing them to do it within 1 month. Don't you think that?
But if you observe that, my lord, two aspect, my lord, two aspect. One aspect, my lord, the time of selection, he was, my lord, facing a criminal trial. At the time of selection, the response was 7, he was, facing a criminal trial. The other aspect, my lord, he does not have a landed property in the charge. The executive instruction as well as the advertisement, it mandates that, my lord, he has to.
Where is the council from Revenue and Disaster Management? They are not there, na? Today they are not appearing in the court, maybe. What to do? Let us have it tomorrow. I'll pass an order. Let's see what can be done. Huh? That is the only order which I say. But if this council will let us wait for some time, let us get hold of the council from Revenue and Disaster. Ask Mr. S. Dutta or anybody to appear. We ask him what is the position and ask, let us be informed by tomorrow what is the position. Why? And then tomorrow we direct passing an order. Huh? Wait for some time. And we will not discharge the caveat so soon so that Mr. Islam doesn't need to go. Let him, Mr. Ali will wait for some time.
Legal options. The petitioner is a cooperative society consisting of the people of the Hira community, my lord, who are engaged in the manufacture of clay and potteries, my lord, in the district of Dorong. They have been allotted with some lands, my lord, in the year 1964 for the purpose of their, my lord, manufacturing earthenware and their livelihood. And
Why
they
is
have-
this matter before me? Why was this matter moved before me? How can I take up this? This is a bench 5 matter. I'm bench 3. Therefore, I'm saying, yeah. You mentioned it before whom? Why did you mention it? Huh? List this matter before the appropriate bench tomorrow. Yes.
But petitioners hearing, they are the research of homeopathic medical college. At the time of filing this petition, always serving in that position. Now some have retired. But,
Whole matter, 2015.
2015 matter.
What do you want?
Yeah, we are claiming for parity of pay with our counterpart in allopathic and ayurvedic.
That matter, we let us wait. Taking into account the matter has been referred to a larger bench. Allopathic and Ayurvedic, na?
No, allopathic and ayurvedic are getting. We are claiming pay parity with them.
This matter I have fixed it on another date. When I have fixed it, I have asked them because you see, now let me tell you without going into much into the facts, I think in the 6th pay commission, there is a year saying that the medical officers of allopathic, homeopathy and
Ayurvedic.
Ayurvedic should be given the same scale.
Yes.
But it is also mentioned that the medical officer homeopathy who is a diploma holder should be given in pay band 3. Now subsequently the governor of Assam have issued another notification sometime in the year 2021 stating that for pay parity in respect to those diploma holders who have 4 years of year, and thereupon the health and family welfare department have submitted various proposals and the finance department has been returning it back.
Yes.
Isn't it the case?
Yes,
My
madam.
case is that ours are teachers. They are professors of the medical, homeopathic medical practice.
Oh.
Petitioners. They are not
Oh,
only
there is a
doctors,
medical officers,
medical officers.
teachers.
Now, present petitioners are the professors of homeopathic medical college.
Where is that? Same?
But pay,
Where is the 6 pay recommendation?
pay commission recommendation, they did not recommend for Chief Miller. That report at page 48.
Where is it?
Page 48.
Of
is the-
state homeopathy requested the commission to suggest AICT pay scale to them, the dental so and so. The commission recommends that all medical officer, this is what they have given, na?
Page 51.
However, the diploma holder medical officers so and so regarding AICT pay scale for teachers of state homeopathic, it is for the government to take a decision in the
Yes.
matter.
Then we applied before the pay anomaly committee, and pay anomaly committee.
What did
report
they
is
do?
there. Lordship will get it at page 50.
All members present were heard
Yes,
the
we did
demand of
our
the
representation.
AICT for the demand to the health on demand. The same was turned down by the on the
From
ground
this
that these colleges
annual
are
committee
imparting
report.
diploma courses and the teachers are diploma holders. But the fact is that these are imparting degree courses at present and many of the teachers are postgraduate holders and so and so. After hearing, they're going to recommend that the AICD may be granted to so and so. So this is the recommendation
Yes, my lord.
to be given and Heather may pass a speaking order so that the aggrieved teacher can approach the appropriate forum for redressal area on the principle of equity and RIA. So the pay committee, an expert body, find you to be in pay parity with them.
Yes, my lord.
Okay.
And
To get
administrative department
AICT
is-
pay scale. Now you are asking for this, you have been doing it, nothing has happened. Now, what does this person say? The pay commission, Iman Inizia stated the committee recommended AICT may be granted to the postgraduate teachers in homeopathy Iman, and if the same cannot be granted for some reason, then there is the Iman. Then what did they do? Contempt case. The matter was examined by finance and some information in the matter was sought from the health, but so far as they received so and so, or to submit specific view. Now, this is the problem with the finance department. Every time you have a cyclostyle type of affidavit, the finance department. This is the exact similar words used. I mean, Mr. Gogoi, kindly read paragraph 10. It is exactly the same which I remember for the other matter. So and so, the matter was examined by the finance department and some information in the matter was sought from the health and family welfare, but so far no reply has been received from the health and family welfare department as yet. Health and family welfare department was requested to submit specific views and comments on the proposal being so and so with justification for granting. Without specific information from here, it is difficult to do so. And health and family welfare, what are you doing?
My lord,
Huh?
so PNI will appear, otherwise my lord, health will have to submit the proposal.
They just submitted the proposal.
Pursuant thereto.
Yes, no, their affidavit says they have submitted proposal for.
No, this is, when have I fixed the other matter?
On 21st.
Well, let us have this matter along with that matter on 21st. Matter is almost same. Other than this, actually, I passed the order. One is putting the buck on the other department, and I said therefore that the government should speak in one voice. And in fact, in that matter, the government was actually speaking in one voice through Mr. B. Gogoi, who was representing both the finance and the health and family welfare department. So today he has asked Mr. D.P. Bora to appear.
Because health says we are entitled and their proposal is.
Okay. Okay, list this matter on so and so on 21 1 along with WPC number.
WPC number, my lord. Yes, I think.
Oblique 2015, na? And in the meantime, you were also thinking that you are going to take the 8-pay commission, the aspect is being taken up. Okay.
I can do.
What is the matter about?
Regarding the holding of the internal committee inquiry, after the price, closing the inquiry by the same authority. For the fourth time, they are going to reopen the same issue. Earlier, price, they said that they won't be proceeding with the matter because there is a criminal case pending on the same issue. And thereafter, in 2022, again, they want to reopen. From 2014 to 2018, price, the same committee said that they will not open.
What matter?
Yes,
Is there direction by some Supreme Court in that regard?
Yes, my lord,
Some
the
directions.
Supreme Court issue was, my lord, the petitioner was under suspension. Suspension was put
Not
to
be
challenge
issued
his
to
honorable
set
court.
aside and quash the inquiry report dated
Direct
in
to
one by
establish of the
the
petition.
inquiry committee as to why
There was appeal by the division bench and it went to the Supreme Court. my lord.
should not be issued to the set aside there.
Education was 376, my lord, in the dean of my lord IIT.
Then
Education with from my lord assistant who was subordinate to me.
so you have been terminated.
No,
Inquiry stopped.
inquiry, my lord, in 2014, when the lawsuit takes up the additional affidavit. We have placed, my lord.
What is the interim order passed? That is directly to be listed, so it will be good.
Yes, sir. Lieutenant was, proceeding initiated by the internal committee to ensure against the official remaining
Internal committee IIT.
19/9/22.
The petitioner is the faculty of the Department of Iman in Iman and relevantly he is under suspension. A criminal proceedings is presently pending against the petitioner on the basis of the first Iman. And the said FIR has been registered as Iman. Have drawn certain proceedings in connection with the affairs of last Iman. It transpires from the minutes of the internal committee held on June and taking note of the fact that it is having been was sub judice before the approval had observed that it would not be put in. Which was spoke by the So what is wrong with the IIT?
No, my lord, now, my lord, they have now again, my lord, constituted a committee, same committee, my lord, with different members. And in 2022, they now want to initiate the same process again. After thrice, my lord, they think that they won't proceed. Because of this, my lord, criminal case. And there is a time bar also, my lord, as per the, my lord, the sexual harassment of women, my lord. That, my lord, beyond 90 days, they cannot do that, my lord. And there is no provision for review also, my lord. That will be the main legal point. Without there being any specific provision in the statute for review, whether they can on their own, my lord, go for review. After their own, my lord, constituted committee, Price, my lord, said that, my lord, it's barred by limitation, now we must not proceed, we will wait for.
Show
the-
me.
Well, that lordship may take up the additional affidavit, I just clear the proceeding file.
Now, where is the provision?
Yes, ma'am.
Simultaneous action of prosecution and initiation of department.
There's prevention and prohibition regulation like 2030, will be dates, my lord. Inquiry was to be under section 11.
Mr. Soikia, get hold of one from government revenue department.
All of them. They have left the board.
We can ask the additional AG then. He's there.
Must have been there.
Yes, others may go except him and Mr. Ali. Others may go. What are you, which provision you are trying to show me?
Yes, but I- Dear my lord, pursuant to complaint received from an employee. The internal committee can, my lord, they conduct an preliminary inquiry and they thereafter can proceed.
No.
Like a departmental proceeding as per provision of section 11.
Sexual harassment of women at a workplace. That's fine. So, which provision you are referring?
11, my lord.
Subject to the provision of 10, the internal committee or the internal as the case may be shall where the respondent is an employee proceed to make inquiry into the complaint according to the provision applicable to the man and when such will exist. Such manner it may be prescribed in the in a period of from registering or registry. It's a criteria. And when
Then possibility 4, subsection 4 also. The inquiry on the subsection shall be completed within a period of 90 days. Then the provision of appeal at section 18. My lord, subsection 4 of 11, my lord, it is 90 days. Then my lord, provision for.
The
appeal at-
inquiry under subsection 1 shall be completed within a period of 90 days.
Then my lord, provision of appeal is there, but no review is there. For revision or review, my lord, there is no provision. 18 is a provision for appeal. any person agree to ensure it will have to be within a period of 90 days. Now, my lord, what was the initial proceedings, my lord, that I would like to place, my lord? Lord, we will see.
No. This is under the sexual harassment of women at workplaces.
The internal committee is there, my lord, in
Now,
every.
this is only for filing a criminal case.
No,
Yes.
but they can proceed, my lord.
No, kindly see. Kindly come to this 11.
Yes, subject to the provisions of section 10.
Section
the
10.
independent committee
Now,
are
what
not
is
to be
10?
constituted.
10 is conciliation.
Yes,
Okay.
as the case may be settled where the respondent is an employee, is fit to make inquiry into the complaint in accordance with the provision of the service rules applicable to the respondent, and where no such rules exist in such manner as may be prescribed, and in case of domestic worker, the local committee shall in prima facie case exists, forward the complaint. Only in case of minor.
No. Forward the complaint to the police.
No,
So, it is only for the purpose of registration,
no.
filing of a criminal case.
No, or in case of domestic worker.
Huh? If prima facie case exists, forward the complaint to the police within a period of 7 days for registering the case. So it is only for the purpose of registering a case, there is a bar to do it within a particular thing. But this does not stop them from going for a disciplinary proceeding. Isn't it the case of disciplinary proceeding?
No, it's not a case of disciplinary.
Disciplinary proceeding.
No. It's not a case of disciplinary proceeding, my lord.
It's a case of disciplinary proceeding.
No, because the FIR having been already registered. So the question does not arise for that.
That's not the issue, my lord.
Now, you say where this particular provision says that there can be no disciplinary proceedings initiated within after a particular period of time. Or does section 11 say anything stopping the initiation of disciplinary
We
proceedings?
will see what is under challenge here. In Lordship, they have today notice now in 2022 to reconsider every aspect.
Where is
Regarding
it?
this, my lord, internal committee, my lord.
Which one?
Yes, let's see. That Lordship will see, my lord. Page 22. Page 70.
This is done under the CCS rules.
Yeah.
So CCS rules is different. They want to continue the proceedings which is initiated as per page 46.
No, that's
Isn't
not
it?
that case, my lord.
Yes. That case, I think it's a fit case for dismissal, right?
No, my lord.
Yes,
Yes.
yes.
Lordship will see, my lord, 27/6/2022, that inquiry report, my lord. But that inquiry report, Lordship will see what is their finding, my lord.
What inquiry report?
That page, my lord, 70.
Page
70.
70.
Impugned hearing, my lord.
Report of the inquiry committee reconstituted under so and
Then
so.
finding of the
dated
committee at
demand
74.
was in year under suspension has been reconstituted to conduct an inquiry into the allegations of complaint petition under so and so the then senior system. The previous day of statement of Gitanjali Iman, statement of Ghoshal, statement of
Then
Ghoshal.
page 75, Lordship will see finally, the inquiry committee feels that the internal complaint committee, under the act, my lord, should examine the allegation afresh, my lord. This is the, my lord, what is under challenge here, my lord. Afresh, in the light of the above observation, the question of examination of the matter being barred by limitation does not arise. So under this act, my lord, they want to examine it afresh, my lord. That is the finding. That's, my lord, we are against that part of it.
You are against this.
Yes, Lordship will see, my lord, the last part. the inquiry committee feels that the internal complaint committee, my lord, under the act, my lord, should examine the allegation afresh, that is the word, my lord. That's why I want to place, my lord, earlier three proceedings, my lord. What was the view of that committee, internal committee? We are against this only, my lord, not against. In fact, my lord, so cause was issued, that was, my lord, they dropped it, lordship will kindly see, my lord. It is part of the petition. Suspension order is there, thereafter, my lord, a detailed so cause was issued. Page, my lord, 46 of the petition, on 15/6/2015. This is under the CCS rules. So called dated 15.
So this is a departmental proceeding.
Yeah, the statement of allegation at page 48.
Yes, then
Then, my lord, we approach the honorable court on the other plea that, my lord, same, my lord, allegation, whatever is there in the, my lord. In the
now what
so-called-
has happened to this case?
During the pendency of the writ petition, they have withdrawn this particular so cause. Lordship will see at page, my lord, 52. It was submitted. Page 52. It was closed accordingly.
The so-called notice dated has since been withdrawn.
No, recall by the,
I don't know what is the final procedure.
they withdrawn it, my lord.
So now you are not suspended any further.
No, I am under suspension, my lord.
How?
My lord,
How you are under suspension?
suspension, my lord,
In view of the
there-
criminal
there was a
proceeding.
direction of the honorable court for reinstatement. That was put to challenge before the division bench. That order was upheld by this honorable court. Then it went to the Supreme Court. Supreme Court interfered with that, my lord. Reinstatement order. So I am under suspension till date. The recent order of the honorable Supreme Court. And honorable Supreme Court has directed that, my lord, whatever criminal case and all are pending against the petitioner, that should be expedited. Trial and all this.
Now what do they want to do?
They want to, my lord, again, lordship will see page 53. 28/3/2022, the internal committee again, my lord, they constituted, and this report at page 70, I have placed, my lord, that was furnished, my lord. Page, my lord, 27/6.
Where is the Supreme Court judgment?
Page, my lord, 157.
Others may go, huh? Only Mr. I.H. Sakia and Mr. R. Ali along with he is there for the revenue and disaster. Others may. Where is the Supreme Court judgment?
My lord, here, page 157. The file on additional letter, it is there.
Now, here, that is the problem. Where is the departmental proceedings?
This is, these are the annexes which I have compiled for,
Now, understood, but where is the departmental proceedings?
that is the proceeding that in state, the ICC, the proceeding taken up by the internal committee was the first stage of the department proceedings.
No, that can't be the departmental proceeding. Departmental proceedings is done under 14 of the CCS Act.
So Lordship, kindly see the act. I just wait the party. It's an act section 4 of the act, Lordship.
No, whatever may be, Mr. Thakuti, don't you think that the departmental proceedings is under the CCS Act rules?
Look,
It
here.
is under the CCS rules. Departmental.
Our rules also, where there is no class, CCR rules also you can follow.
No, you initiated under the first, under rule 14 of the CCS rules.
We have initiated under this act, Lordship. Section 4 of this act, the internal committee. Now, Lordship, there is some confusion of facts, if I can narrate the facts. Lordship.
Please.
Now, Lordship, about under this act, Lordship, every employee has to constitute one internal committee. Now, that committee, Lordship, will make an inquiry under section 11. Then under section 13, the inquiry report.
But 11 inquiries to what extent? Let us see what is the inquiry contemplated in 11.
Read out. Lordship.
Yes.
Reading out. Subject to the provisions of section 10, the internal committee or the local committee, as the case may be, shall, where the respondent is an employee, proceed to make inquiry into the complaint in accordance with the provisions of the service rules applicable to the respondent, and where no such rules exist, in such manner as may be prescribed, or in case of domestic order, the local committee shall, if prima facie case exists, forward the complaint to the police within a period of 7 days for registering a case under section 509 of the Indian Penal Code and any other relevant provisions. Here, Lordship, the lady, victim lady, she already forwarded lodged an FIR that was registered. It's a criminal case going on. Now she forwarded a copy of that to the internal committee also, because the FIR discloses, complaint discloses the two sets of offences. One is under 376. Court has registered a proceeding under 376. The other one, the complaint discloses that for a period of 2 years or more, the gentleman lead petitioner was subjecting her to sexual harassment.
Let us assume everything is true, but my question is, what is the final outcome of a section 11 proceedings? It's a criminal proceeding.
Yes,
It's not a departmental proceedings
it is proceeding under this act.
under this act. So it will lead to a filing of a criminal case under the IPC.
That is, we are not comparing now.
We are not on that.
We are-
Now, where is the departmental proceedings under 14?
Now, Lordship, that department proceedings means the proceedings here, the department proceedings cannot start. Lordship, you kindly read to para 13. Just as
Of?
the Lordship, that section 13,
Ah.
inquiry report. On the completion of the inquiry under this act, the internal committee of the local committee, as the case may be, shall provide a report of its findings to the employer as the case may be, or district judge, etc. Lordship, that come down to subclause 3.
Hmm.
Where the internal committee or the local committee, as the case may be, arrives at a conclusion that the allegation against the respondent has been proved, it shall recommend to the employer or the district officer, as the case may be, to take action of sexual harassment as a misconduct in accordance with the provisions of the service rules applicable to the respondent, or where no such service rules have been made in such manner as may be prescribed. That means, Lordship, is internal committee finds something substantial, is proved, then it will recommend that as a misconduct, it can be proceeded by the department proceeding as per the rules. Now here, Lordship, what happened? So without inquiry by the IC, internal committee, the DP cannot be started. This is the first stage of the DP, department proceedings. Here DP has been stayed by the Honorable Court, or this internal committee's proceedings has been stayed by the Honorable Court. So DP, the initial part of the DP is the inquiry by the internal committee under section 4. The committee proceeds under section 11, then finds a report under section 13. But here, Lordship, that whole controversies arising, disputes arising.
On 11, section 11, may I clarify, madam? It's not the police case. Madam. There are two aspects, madam, in section 11. One, for domestic help, it will be, madam, FIR.
So you, Mr. Kakote, you mean to say that without the internal inquiry report,
Lordship,
there cannot be a concept of misconduct.
Lordship. Yes, Lordship. It has happened.
And to treat it as a misconduct for initiation of action under clause rule 14 of the CCS rules.
Yes, the CCS is similar. Rule 14 of CCS rules.
So therefore, you initiated the aspect
Lordship.
by issuance of show cause notice
Lordship.
was premature.
No, that way we done it on technical ground.
So
The
you,
show cause
it was
notice-
premature, so
Lordship,
therefore
that's
you withdrew
premature, but
it
technically
without
we
that.
done it. But you do not bar us from proceeding again. Now we have
No,
realized that unless and
Now,
until.
if you see, kindly see 19. Because as you say, 13 says, when a report is given as regards sexual harassment, it would amount to a misconduct
Lordship.
as per the service rules.
Yes, Lordship.
Now kindly see 19I. Every employer shall treat sexual harassment as a misconduct under the service rules and initiate action for such misconduct. 99.
Section 19, Lordship, every employer shall treat as a misconduct under section rules and initiate action for such misconduct. Yes, Lordship.
So therefore, you want to say that you have initiated the initial internal inquiry report, the committee, while this matter was being taken up.
Lordship.
For some reasons, it got stayed or whatever it may be,
Lordship.
or you initially did not proceed with it.
Lordship.
Now, later on, you wanted to proceed with it because without proceeding with it, without that recommendation being given by the internal report,
Lordship.
it cannot be a case for misconduct
Lordship.
or invoking proceedings under the CCS rules.
Lordship.
That's your case.
That's the case. Now, here the problem is that matter was initially sent to the internal committee as existed that time.
2024 or 14.
14. The committee made some mistakes, Lordship, serious mistakes. There, the complaint was forwarded to the committee, they misunderstood the complaint. Complaint discloses two sets of offences. One is rape under 376, case was registered by the police, it is proceeding. The another one, on examination of the complaint, we have found that there has been constantly an act of sexual harassment on the lady by this lead petitioner. So that aspect, the sexual harassment, has to be proceeded with under this act. Act 13, that means under internal, must be sent to the internal committee. So it was initially submitted to the internal committee by the victim lady, and the committee misunderstood the whole thing. The committee took it huge.
Okay, now, if the internal committee makes a mistake,
Lordship,
what can be done?
that we have referred it, clarified, referred it again.
No. Can you keep on referring? Because it is an opinion. For example, the internal committee did not submit the recommendation. Let's take.
No, they did not proceed at all. They did not look up. They said, we have no jurisdiction because criminal court has taken over the matter.
Okay,
That
so
was not
they did not proceed.
No, they did not proceed. They said, we have no jurisdiction since the criminal case has taken over the matter.
Okay,
But
so
criminal court has taken over-
thereupon,
Lordship,
you proceeded.
we again issued.
You again requested the
Lordship,
internal
yes.
to proceed.
We constituted a committee, Lordship, to examine entire things. The committee suggested that the internal committee's initial actions are totally wrong. They thought they have no jurisdiction, but this is the matter, this is different. That is criminal side, and in the disciplinary side, internal committee has to examine, must give a report, and the report is positive, then as a misconduct, this will proceed, will continue.
Yeah.
Now, when we have, our committee has given this report, then we have issued in notice. We have sent a matter to the committee, internal committee again. Committee has given a notice. He has stated that he challenged the committee's report, that notice, saying that you have already decided. He found nothing against me. He cannot decide. Again, you cannot make an inquiry. But in that committee, at the very beginning, the committee said, earlier committee, Lordship, that we have no jurisdiction because the criminal case has taken over, competent criminal case has taken over the matter. But the other aspect of the complaints, the sexual harassments, on that committee was silent. They misunderstood everything. Now we have realized that no, we cannot proceed unless and until the internal committee again inquires into the matter. Therefore, Lordship, second notice was given to the wider internal committee, asking him, notice was given, asking him to be present, that they has challenged. On the ground that it will double your party, you cannot inquire again and again. But initial inquiry, internal committee, never given him any summons. He never made to appear with the committee because the threshold committee told that they have no jurisdiction.
So you say
Lordship.
that the committee did not make any recommendation, neither rejected any recommendation.
They said we have no jurisdiction to prosecute.
So therefore, the
Lordship.
committee did neither make a recommendation nor refused to make a recommendation.
Correct,
In
Lordship.
fact, the committee did not do anything
Yes, exactly
on,
correct.
on an assumption that they don't have the jurisdiction.
Lordship,
But once the matter goes to the committee,
Lordship.
the committee has to do it within 90 days.
No.
How do you take care of that?
No, 90 days, Lordship, that is, once the matter is, Lordship, only section 9,
11.4.
the inquiry under subsection shall be completed within a period of 90 days. Here the inquiry had not taken place at all. So Lordship, that
The inquiry will start from when?
when this inquiry under section 10,
No, no, kindly see 11.1,
Sorry,
subject to the provisions of section 10.
Lordship,
The internal committee or the sworn as the case may be, shall where the respondent is an employee proceed to make an inquiry into the complaint in accordance with the provisions of so and so in such manner as may be prescribed or in the case of a domestic local committee if the human so and so within a period of 7 days from registering for the registering of the case under so and so and forward the complaint to the police under so and so, provided where the aggrieved person informs the internal committee as the case may be that any terms, provided further that where both the parties are employed, the parties shall be given opportunity of being heard, notwithstanding a year for the purpose of inquiry.
here I beg to submit, Lordship, that when that
Now, when will the inquiry start?
inquiry starts under section 11, when that complaint, they have received the complaint, they read the complaint, then start the
So the
inquiry.
inquiry, if it starts, it has to complete within 90 days.
But here, Lordship, that,
They didn't do anything. That's another aspect.
Lordship,
It's another aspect. They didn't do anything. But the fact remains that the inquiry started with the complaint being submitted.
that
And rightly or wrongly,
is,
the inquiry committee did not do anything.
the inquiry has not been started at all. That's why substitute 4 is in-
Therefore, I'm saying,
Lordship,
how the inquiry would start? You say that this inquiry would start with the submission of the complaint.
Lordship.
If it starts with the complaint, it has to end also.
By my interpretation may be wrong, but inquiry means inquiry, Lordship. They receive the copy and give you, they have, it's a- Lordship, the complaint discloses a 2 years constant sexual harassment of the lady. So that part will totally now wiped out.
Mr. Kakoti, I am fully in your thing that this should be, the writ petition should be dismissed. I'm with you. There is a case of sexual harassment and all. But the law says that you have to complete the inquiry within 90 days.
Very correct, Lord. Lost.
Now, if they don't complete or don't do anything, they keep the inquiry in abeyance. Do they have the power to keep the inquiry in abeyance?
They said we have no jurisdiction to proceed with this.
So therefore, it was a wrong thing. Means they did not make a recommendation or made a recommendation to the effect that we cannot inquire.
They did not inquire at all. They did not start the inquiry.
No, they say that in view of a criminal trial going on, we don't have a jurisdiction.
Lordship,
Meaning thereby, they did not make a recommendation,
Lordship.
which they were otherwise required to do.
Recommendation comes only at the end of the inquiry, Lordship. The inquiry is concluded, recommendation comes either way. Here that inquiry had not started at all in subsection 4.
Kindly come to 18. How an appeal lies. Any person aggrieved from the recommendation made in subsection 2 of section 13 or under clause 1 or clause 2 of subsection 3 of section 13 or subsection 1 or subsection 2 of section 14 or or non-implementation of such recommendation may prefer an appeal to the court or the tribunal in accordance with the provisions of the service rules applicable to that person, or when no such service rules exist, then without prejudice.
My submission, Lordship, that the recommendation had not happened here. This way, that way, neither way. The question of section 18 cannot be brought in this case.
Hello, we'll look into it after reopening.
Lords.
We fix it on 7th of February.
Lords. But only difficulty that the domestic inquiry, Supreme Court says you must finish it within 6 months. So that, of course.
Then the Supreme Court, look here, we got a whole of a judge out there who doesn't finish it off. They will know. Don't worry, we'll finish it up. I'm taking it up now. I'll finish it off on 7 or earlier. You see, not possible. It's, you see, the courts are closed. Tomorrow it's closed. Then it's very difficult. Let us try our luck on 29th then. 29th.
Lords, yes.
7, my lord, it is a Saturday, it will be more convenient, my lord, so you can hear the matter, my lord, entirely. On 7, let it be at 7. But Saturday, my lord, we will be working this time, my lord. They are on regular basis.
7th of, huh?
7.
Let it be on 29th, Lordship. 7th, some difficulties may be there because let it be on 29th, Lordship. We'll try on 29th, Lordship.
My lord, in that case, on 5th, my lord, considering the urgency. Yes, some, my lord.
5th of February.
Yes.
Lordship, please, yes.
If not in that, my lord.
7.
Lordship.
This will take some time.
Yeah, Lordship.
You see, one has to go through it. One has to understand that. So, okay, the matter having been heard, substantially heard, list this matter again on 7/1/2026 at the top of the list for final disposal. Yes, where did you get hold of? Yeah.
My pen is there, my lord. As my revenue concepts are not there, my lord.
Mr. Gogoi, you being the additional Advocate General, I'm having this matter tomorrow. It's not that. Here, what has happened? He initially challenged the post of the selection of him as a Gaubura. When the matter was taken up by the learned coordinate bench, the Revenue Department said that there is a provision of appeal under 162D. So the court said that, okay, you file an appeal within 7 days. And if you file an appeal, till then the status quo be remained. Further giving the liberty to the petitioner out here to seek interim directions from the commissioner and secretary, who is the appellate authority. Within 7 days or whatever may be, they filed within that period, they filed their review. The commissioner and secretary, as per the petitioner, is sitting over it, not done anything, neither passed any order. On the other hand, on 5/1/2026, he was appointed as the Gao Pradhan. 6/1/2026, the circular officer gives him an unilateral charge. 7/1/2006, he has taken over. So he has again approached this court in action here. My only question is for tomorrow, because what order I will pass is that to dispose of the appeal within a period of 1 month. That is what I propose to pass tomorrow. But you only find out what has happened before the appeal, before the commissioner will take it up tomorrow. That's list the matter tomorrow for motion. Yes.
Your Lordship, kindly excuse me. In regard to item 15, my lord, can it be taken on 19th?
Where?
1/5.
Item 15.
A short, very short matter.
15, na?
Yes,
Okay. When do you want?
on reopening, my lord, on 19th, 1/9.
Okay. I won't be sitting. 19. List the matter on 19/1/2026.
Interim order will continue till.
Interim order passed earlier shall continue.
Tomorrow, is it possible?
Tomorrow, not possible. Don't there.
Not to-
Don't trouble Mr. Chaudhary on tomorrow.
I know he's very busy.
Item number 25, can it be taken up on a fixed date anytime after the vacations?
25, what is that?
Is the hearing matter, my lord, regarding reverting of an officer of the Assam Public Service Commission, my lord?
Hearing,
Hearing, my lord. 7th of February, my lord.
that is a 24 matter. You see, the problem is now these 2015, 14 matters are so many out here now, you can't proceed so much. Give me some time to just, do it with, this bench has been not in proper shape.
No, it will come to the proper shape now. my lord.
Ah,
It is in the
we
course
need
of coming to the-
at least 6 months' time to bring it into shape. Yeah, it's in very bad shape now. Okay, we have it on
7th of February. my lord.
3rd of February or 7th?
7th.
No, the 7th.
Item 2, my lord, the interim may continue.
Item number 2 is into Asanam. Interim order passed earlier shall continue.
My lord, wishing a happy Bihu. Wishing a happy Bihu to your lordship. my lord.
Huh?
Wishing a happy Bihu to your lordship.
Oh, thank you, thank you, thank you. You don't have many matters tomorrow.
Lordships, item number 18 and 19, Lordships. 18 and 19, Lordships, it's in the hearing column, Lordships. This is 2021 matter, Lordships. The petitioner already been promoted. That is a stay order operating against the respondent number 7, Lordships. It is at that stage, Lordships. Already been promoted, Lordship. This is the.
Here, petitioner has been promoted. This is the text.
Now, what do you want?
Lordships.
Let it be.
It's not the person as well. Lordship, only the person has been promoted, petitioner. So, Lordships, nothing survives in the matter, Lordship.
Nothing
My-
survives.
nothing
You are for the petitioner.
I'm for the respondent, Lordship.
But then,
Yeah, Mr. J. Busso is the counsel for the petitioner. Lordship, Madam,
we do one thing, let us have this matter on 20 at 2 p.m.
Yes,
Made big, Lordships. I'm so grateful.
18 and 19, 20 at 2 p.m.
I'm so grateful.
Only item number 11 and 12, short matter, kind.
No, there is no short matter. These are all long matters. So
Statement
many matters are listed.
On the
You
basis
see,
of
yeah. One matter takes some time out here. Let me get used to it and pass it.
Date will fix, my lord, after.
Date you take dates, but don't give it now. February last week.
Lordship, item 18 and 19, there is an interim order, Lordship, that may be continued.
The interim order passed earlier shall continue. If any, shall